I have a question. Are the cameras are on? Are we live streaming right now?
Yes.
Okay, so I will make 2 points. Number one, I wasn't, and I don't think any other member of the court was notified that we were live streaming. So since we have a rule on that, I will make a motion that we suspend the rules and allow live streaming for today's business meeting.
Second.
And would appreciate in the future if we're notified before we're put on camera.
And it, I guess. So. There's a problem with is your mic on? So I have the live stream on and it's only showcasing Justice Womack, but so Justice Baker, again, why would you only notify Justice Hudson of media arriving and of the live streaming?
I thought the court was all aware of it.
How would you think we would be aware of that?
That I announced to the public that we were going to be open about administrative matters. And I don't agree with that.
All right. Well, I guess in the future, I'd ask that if you were notifying the court of something, you'd notify the entire court, since we are a collaborative court. Thank you.
So Sean's got a motion. Is there a second?
Second.
Any discussion? All in favor?
Hi.
Motion carries. I will continue the Office of Attorney Regulation Council with Mr. Bar exam, screen each applicant for character and fitness to law in Arkansas, and enforce all other attorney admission and annual registration functions. And the office educates the public and legal profession on the underlying duties and requirements of the Arkansas Rules of Professional Conduct. The office will enforce the Arkansas rules regarding attorney discipline and disability proceedings and mandatory continuing legal education. When necessary, the office oversees the client files for attorneys who can no longer practice law. Yes. The Office of Regulation Counsel also investigates and prosecutes individuals who harm consumers by engaging in the unauthorized practice of law. The Office of Attorney Regulation Counsel works with 5 permanent Supreme Court committees to regulate the practice of law. And so there would be in this position, the Attorney Regulation Counsel, which is Nancy Gibbons, Deputy Director, and 2 staff attorneys. And this would allow us to consolidate and eliminate current positions. We would have a grievance coordinator, CLE program manager, CLE database manager, admissions deputy, and executive assistants. So Michelle Wise is the license fee director in the clerk's office, but is paid by the Bar of Arkansas. So I think she should be in the Office of Attorney Regulation Counsel for oversight and fee processing, but that's still done through the clerk's office. And there is a paralegal position in professional conduct, and we might need to change her role to something else. But that would be the only employment changes. But
Can you point me to the page that deals with this grievance manager that you mentioned?
I don't think I didn't. The Attorney Regulation Council, Deputy Director, 2 staff attorneys, investigator, and grievance coordinator.
Grievance coordinator, not manager. Okay, so where is that in this? And I'm not sure what you're reading from. I don't think we have what you're reading from. We have a 42-page document that is drafted like a bill or a rule change. But apparently you've got information on positions over there that we don't have.
Their,
Justice Baker, you may need to press your mic when you talk.
it's on.
It doesn't switch back and forth.
Yeah, whenever we see our faces, I guess that means the mic is on, I mean, the picture's on us. Not online.
It's delayed on them.
Yeah, run your next one. So again, my question was, you mentioned a grievance council. Or was it council manager? I'm sorry, what was it you said with some sort of grievance position?
Grievance coordinator.
Coordinator, okay. Is that a new position?
Let's see, it's not a new position. It would-
Can you put your mic on?
There you go.
No, it would not be adding a new position. It's changing a title, and this actually is based on or drafted in a manner that was kind of consistent with Indiana, the way they do their attorney regulation. So yes, it's there are a lot of changes in the rules, but it's mostly changing things like the name. The executive director of the Committee on Professional Conduct is changed to the Attorney Regulation Council.
So explain to me how when Nancy Gibbons has come in here to budget meetings, she has always said she's overworked and has too much on her plate. And, you know, we've asked her about trying to digitize what she does, and the fact that we're one of the few states that doesn't have, you know, online applications and the ability to do things, that now we suddenly are going to give her more responsibility. How do you justify that?
Well, Nancy has worked 12 years for Office of Professional Conduct under Stark. And then she moved to professional programs. And she's been there, I think, 12 years. And I believe that she has the experience to oversee both. As you know, in professional conduct, we have not had executive director or one of the staff attorney positions filled. And she's recommending not filling that position and the staff attorney position. And she would oversee professional conduct. I think we're not going to find a more qualified applicant than that. Historically, it was one office, and then Chris Thomas was the director of AOC. And at the time, a new chief judge came in and relieved him, and they separated that and put Chris Thomas in charge of the bar applications, basically. But I don't believe Nancy has said she's overworked.
Yeah, so I think that wasn't really my answer to my question, but so yes, Nancy and Lisa Ballard both claim to have too much work and repeatedly asked for more staff. So that was my question. Was how she could now oversee more when she had requested more staff.
I don't think that's true. I
Okay.
don't think that she has
Okay,
ever claimed that she was overworked.
okay. Do you recall the how many investigations they have active and pending right now in professional conduct?
No, I don't know that.
So you don't know how much backlog she'd have to address on top of her current and new responsibilities?
Of course, Charlene Fleetwood has been solely in charge of investigations at this time, and I'm not sure how much backlog has developed in the last 8 months, that no one has been overseeing professional conduct. But I think it's time to move forward, and to move forward with this would be placing the regulation of everything concerning the attorneys in under one umbrella. And
I think it would be helpful to know what the backlog is before we assign more work to someone.
okay. That might be helpful.
Thank you.
So I would go back to my question, this grievance coordinator. Again, it's a 42-page document we just got this morning, but in flipping through it, I don't see that referenced anywhere. And you said it was just a changing of a title. What's the current title of the position that you're planning to use, and who's in that position?
No, I think the only people are the staff attorneys position that is not filled. There's 2 staff attorney positions not filled at OPC.
So your plan is to take one of the staff attorney positions and rename that grievance coordinator?
I think that may just be
I don't know if your mic is on.
Yeah.
it's green. Would be a title. And I'm not actually sure that that's it's just there's, I guess, activities that are assigned to that.
What would the job of the grievance coordinator be? What grievances would they be hearing?
Grievances against attorneys. The public's grievances.
So essentially like the discipline complaints that professional conduct gets now.
Yes,
Okay. So between the 2 offices.
Again, I have to ask if you wanted transparency, so can you try to be diligent on, let's try to all turn our mics on and off when we answer.
I'm trying to turn mine off.
I know, but she's not, so we can turn.
I think it defaults back to her when we turn ours off.
We just need to hit our call.
So, yeah, so after I ask the question, I'll turn it off. So you'll be on screen when you answer, but so of the offices that you're proposing to consolidate, how many total positions are there now, and how many positions would there be afterwards?
I think there would be 1 director less than there is now, and 1 staff attorney position less than there is currently.
So this would eliminate 2 currently funded positions.
Right.
And are we giving new authority to any of these people?
No, I don't think so.
Okay. Again, I mean, I'm a little concerned that we have this new title grievance coordinator, but we don't have any reference to it in the document that you gave us that I can find. So if you have something on what that would be job wise and how it would be different than just a staff attorney, if you could get that to us. I think that might be helpful.
Related to Justice Womack's question, is there an electronic version of this document somebody can send me? Because it's a little hard to flip through 42
Yes.
pages print. Can somebody send that to me now?
Yes. Sure. You want to get it now?
I think she was gonna, can you ask her?
Okay.
Sorry.
I don't use paper. Search.
I only know how to search some. Kids.
There's no real best help for me.
Yeah, I didn't see that.
I mean, I can read it word for word.
Yeah, I just wanted
I
to make sure I
think
didn't
it's
miss
the
something.
coordinator, and I'm not sure that Nancy has planned, other than, I don't think it's an attorney position.
Thank you.
You don't think it's an attorney position? Just the coordinator? I don't.
So I'm confused by that then, because you said that you were just retitling the staff attorney position. But now you're saying it's not an attorney position.
I'm not sure, to tell you the truth. If employees of the Office of Regulation Counsel is something that they've suggested. But she also has 2 staff attorneys.
Is the paralegal position, is that maybe what a grievance coordinator or, and is that what Ally Mack is maybe now? That would,
I'm
Yeah.
not sure.
okay.
I'm not sure you're probably more familiar with the attorneys and staff that are over in what is currently professional conduct.
Is Ally Mack gone now?
No, as I understand it, Ally Mack is there and she has paralegal training. And there is a receptionist, Caroline. Charlene Fleetwood is still there as interim. And before Lisa Ballard left, a young man named Cameron had taken a job with the city of Little Rock, I think. So he is gone. And then Anna Catherine Cargill resigned.
Right.
So there's 2 open staff attorney spots. And I guess Ally Mack has a skill level, higher maybe than just an administrative assistant.
Okay. I knew she was there a week or so ago, but I thought you were saying she was her position was being replaced. So I apologize if I misunderstood that.
I think Anna Cargill, she was terminated. We fired her.
She officially resigned. I mean, by vote of the court, but
Yes.
yeah.
Justice Baker, in the interest of time, since we just received this, would it be a better idea to allow us a chance to review it and go through it and give you a chance to
Certainly.
bone up
would.
on it? And so I guess I'll move that we table this particular item until the next meeting.
And I would second that motion.
All in favor?
Aye.
And the motion carries. The next item of business is Justice Wood, I believe, suggested and I took it to be a request for an update on JLAP and criminal conduct that has occurred. There was an issue with an employee, Miss Knowles, who was employed by JLAP. This was November of 2022 when it was discovered, so it's been some time. And I suppose it came to your attention because it was in the media when a lawsuit was filed by the foundation to recover approximately $40,400 that Ms. Knowles had embezzled from the JLAP Foundation. Jennifer has reported that at the time, the executive and deputy chair and treasurer were signatories on the foundation's accounts. And the chair and I informed, or the chair and Jennifer informed the bank that it was, they had caught a forged signature. And when Chairman Park and Jennifer informed the bank that it was in fact not Jennifer's signature and requested a fraud investigation for the foundation's account. On the same evening, an emergency meeting was held of the JLAP Foundation officers, the chair, vice chair, secretary, and treasurer, the JLAP committee chair, and the JLAP executive director to discuss this. During the meeting, it was decided to immediately remove any access to Ms. Knowles and that she could not have anything relating to JLAP, the foundation, or the program. As a former JLAP employee, Ms. Knowles had been contracted by the foundation to assist with accounting and fundraising in August of 2022, after she resigned from the administrative assistant position on the JLAP staff. So at the time this was discovered, she was an employee of the foundation. During the emergency meeting of the foundation, the officers agreed to file a police report pursuing criminal charges, as well as the then Chief Justice and AOC Director were advised of the situation. On November 9th and 10th of 2022, further bank investigations were conducted, and Ms. Knowles confessed to Chair Park that she wrote each of the checks and fraudulently signed Jennifer's name. A police report was filed with the Little Rock Police Department, and everyone was advised of those events. Over the next several days, the bank would discover there was a total of 24 checks made directly payable to Victoria Knowles, and that Jennifer's signature was forged on each, totaling $41,000. Jennifer signed an affidavit with the bank attesting that the signatures were not genuine, and we've been waiting to possibly testify in court. But as far as Jennifer's aware, and as far as the JLAP Foundation is aware, the criminal charges have not gone forward. I'm not sure why. The JLAP Foundation has since modified its bylaws and procedures so that they have more financial oversight and accountability between the officers. Only JLAP Foundation chair and the treasurer have signatory rights over their accounts. And it's Jennifer's understanding that the foundation continues to pursue the criminal charges, and they filed the civil case in December of 2024 to protect their rights, given the time lapse, and to maximize the chance of restitution. That is the report. At the time it was discovered on November of 2022, it was reported to Chief Justice Kemp, and it was reported to Marty Sullivan. So they were made aware at that time. I was not made aware of it as the liaison, and I'm not sure why that was. But at any rate, I was never told about it, and I learned, same as you did, from the filing of the civil, or that I imagine you did, from the filing of the civil lawsuit, because Barrett Moore contacted me to tell me that he was filing a civil lawsuit. That's all I know about the situation, and I think that's all there is to know. I'm not sure if anybody has contacts in the Pulaski County to see why criminal charges have not been filed and pursued.
So I have a question, and I don't know if in 2022, if that was the period that Justice Hudson, there was a period of time that Justice Hudson took over JLAP because you were unavailable. Do you recall if that was the period that you had taken over JLAP?
It could have been, I can't say for sure, but I certainly was not notified of any misdoings at the JLAP Foundation. I had never been in contact with the JLAP Foundation, but only Jennifer Donaldson and her staff, are employees at JLAP.
My concern was that when I saw, the first I knew was in the paper, but that in 2022, the fall of 2022 was when JLUP went over $200,000 budget, and the hole was during that time period. And, you know, full disclosure and transparency, that was the period you were unavailable. And I received a phone call from the foundation saying that they could not reach you, and they were concerned because that payroll was not going to be paid. And they asked if the court could make arrangements to make sure that employees were paid. And this court had to act and transfer funds over $200,000 into the JLAP budget during that time period. And so my concern is that that's the same time period that then there's money missing out of a different fund in JLAP.
As you know, the JLAP Foundation is a 501c3 corporation, and it's separate from our oversight. They had hired Ms. Knowles, and I'm not, Justice Hudson had agreed in the spring of 2022 to be available for Jennifer if there was any issues. But I was back at work in the fall, and this was discovered in November. So it was reported to the Chief Justice. I'm not sure why you received a call, but the transferring of funds was because the Chief Justice had agreed to a wellness initiative, and they had developed that program, which involved essentially $200,000. And that was then canceled by the court. That is why the wellness initiative was canceled. I was unaware of this embezzlement, and they didn't contact me, and I guess they didn't contact Justice Hudson. I'm not sure why they contacted you, but
just to be clear, they didn't contact me about the embezzlement. I just read it in the paper. If you misheard what I just said, that's what I had said.
I thought you said the JLAP Foundation contacted you.
What I said, it was in the fall of when they could not make payroll, JLAP Foundation and the board contacted me because they couldn't reach anyone to figure out how to pay payroll with JLAP, the organization. And they were concerned. And that was when the court had to fund money.
Did they contact the Chief Justice then?
I directed them to, yes, contact the Chief Justice. But that was not about the embezzlement or the foundation. That was about our court.
So that must have been when we transferred that 200,000 from client security fund. Yes, okay. Right.
So y'all help me, maybe I misremembered, but we had budget hearings with JLAP. $40,000 embezzlement, even though it's a foundation, I understand that, but we still had conversations about the foundation and funding was a big deal. Why in the world didn't we hear about this at that budget hearing?
I don't know. Be
That's,
a good question for Chief Justice
I
Kemp
mean, that's,
or Marty Sullivan, but I was not informed of it. I understand the two of them were very aware of it.
Well, Karen, I don't want to interrupt, but I think actually it was the responsibility of JLAP, Jennifer and the liaison then, which would have been you, to make that report during the budget hearings. So that's just my.
I'm not sure could make the report when I was totally unaware of it. It was
Well,
not ever
I
reported to
give you
me.
that if you were not made aware, but
But the Chief Justice.
But we asked
and Marty
Jennifer-
Sullivan were made aware of it.
we asked Jennifer a lot of questions about her budget during that process. And I just don't know, I don't recall her saying anything about.
She didn't say anything about it. I don't know it, and I didn't know anything about it. I was not aware of it until they contacted me to tell me they were filing the lawsuit.
Okay.
But I understand the Chief Justice was aware of it because it was reported to him. And it actually didn't have anything to do with JLAP, our program, it's the foundation.
As just one further point, though, I thought that it was our employee signature that was forged. Is that
She
incorrect?
was not our employee at the
No.
time.
Jennifer. Was
Oh,
it?
Jennifer's, yes.
It was our employee's signature that was forged.
Yes.
Okay.
Justice Baker, just to clarify, we haven't heard from the prosecuting attorney's office about follow-up on criminal charges.
No.
I'll be glad to reach out to them and see what's going on if you would like me to. Or Justice Holland might prefer to.
How long ago was that?
It was November of 2022.
When it was referred to the prosecutor's office?
Yes.
Okay.
And I understand there has been contact. Of course, we had a new chair now. And that Barrett Moore had contacted the prosecuting attorney's office about why or in what manner they were proceeding. But it'd be great for either one of you, since you have contacts in the prosecutor's office. Actually, Cody, I think would be. If you're willing to contact him.
Well, that's the only thing. I mean, technically it's JLAP is the victim. I mean, obviously the victim has the right to contact. Let me think about the best way to ethically handle that.
All right. And that's all that I have to report about that.
Karen, may I ask, how do you know that the Chief Justice Kemp at the time and Marty Sullivan knew about this incident?
Jennifer said it was reported. This was shortly around the time of the advocates dinner and in November 8th, I think, that it came to light and it was reported to Jennifer says it was reported to the Chief Justice and to Marty Sullivan.
But you don't know that yourself.
No. No. Or why she decided not to contact the liaison. But that is apparently her feeling that it was appropriate to go to the Chief Justice for that. And I suppose it was his decision not to inform the court about it. There's a copy of the complaint that sets out the facts, and you can see. So, anything further on that item? So item 3 is the carpet update. Justice Wood.
Yes, I just wanted to know the status as Chief Justice, if you could give us the status.
The status as far as the carpet is that the bid, there was never a bid on the carpet. There was a quote to Melanie for carpet in the offices that had asked for new carpet. And I think the remaining offices either didn't want, or I'm not sure how many people wanted carpet, but the quote was $75,000 to carpet those offices that were requesting carpet. And of course, there was the question from you about priority. I told Melanie that that was too much money, and we weren't going to do it. If the court wants to proceed with getting carpet, I think we are going to have to do it one office at a time, and that the priority would be, I'm not going to ask for new carpet. Justice Wood, I think you are. You're not? Okay. So the status of the carpet is we're not getting any. We just couldn't, I couldn't see that cost.
I know that, I think, Marty would have to correct me with the term, but I think that part of the cost was not coming out of, Supreme Court budget. It was because the carpet was 30 years old. Had you found out from Melanie how much was not covered, just because the state building services, I mean, they pay for, Central Building Services pays for routine carpet replacement. So do you know how much of that was covered by them?
No, Melanie just told me that the quote she got was it was going to be $75,000, and I couldn't see spending that amount of money. But I understood which offices had requested carpet update.
I do not need new carpet and I do not need new paint. Just.
I requested new carpet because Justice Hart had this office before me, and it had a very significant odor of cigarette smoke, and I believe her pet had been in the office. I've been in the office now for 3-4 years and bought area rugs with my own money to cover as much of that as I could, but that carpet needs to be replaced. Whether you do it while I'm in the court, while I'm in that office, or someone else, but it is in bad shape.
I will add that I deferred carpet to our newest justice, because he took my old office and the carpet was in terrible shape the whole 10 years that I was there. And so if there was a priority in limited funds, then I deferred to carpet that was in worse condition, and it's in pretty bad condition. So.
Yeah, I can affirm it's in pretty bad condition. But if it's as simple as cleaning it, that's fine with me. But there are some spots that are really bad.
And I'd also requested carpet because ours is in pretty bad shape. We've got some stains on there where the cleaning crew comes in with their cart. And now we have paint on our carpet. So I would suggest maybe they rebid it on a one office because all the offices are the same size, or I guess the corners are maybe slightly different, but maybe rebid it on one office at a time so we can get individual quotes and then work with building services to see how much they would cover as part of the routine maintenance since they own the building and once we get that information, decide how to proceed.
Justice Baker, was the 75,000 figure that Melanie gave you, was that inclusive of building services or exclusive? Because I know they chip in some. Do we know what?
I don't know.
No one, okay.
She just told me the total cost.
And that was including the conference room, which that just had carpet replaced recently, so that
Right.
didn't need it. I don't think any of us had asked for
When they
that.
redid the hallways, sorry, when they redid the hallways, they did the conference room at that time, and I agree, it doesn't. Or I'll agree that there are areas that need replacing a lot more. But I was just going to suggest we go by priority in seniority. If you're willing to defer, it would go to Sean and then Barbara. But I don't know if we're going to be able to do any of it because I'm not sure how much funds are going to be.
So Marty, if you could maybe work with building services and see if they can get actual bids instead of just a rough estimate on like a per office basis. On how much it would cost and how much they would cover and see if it's something that's feasible for us to do. Thanks.
All right. Oral arguments, Justice Willard.
Yes, so I asked for oral arguments to be placed on the agenda because one of the benefits of running for office is that you travel around the state. I know, Barbara and I spent a lot of time, and Sean and Courtney, that we visited with a lot of people. And one of the things that we heard from the bar was that the court, there's been a decline in oral arguments. And I've noticed a decline in request for oral arguments. So I don't know that necessarily the court has not granted as many, but there have been fewer requests than what we've seen in the past. And maybe that has something to do with, the COVID era that played a part. But it used to seem like every conference date we had an oral argument when I first joined the court. And now we don't seem to have as many. And so I propose that that we consider whether flipping the script on that or either issuing a statement or issuing a proposed rule change or just some sort of proposal for comments on that. But I know that we recently set oral argument in a case that was not asked for February 6th. Several of us voted to deny that, and I think that was for a different reason. But if we consider either saying that every case is set for oral argument with the briefs, an attorney with the brief can instead submit a letter saying why they do not think it merits oral argument. And then the court, when it comes up to us, could consider, upon review, when we see the briefs, voting to say we take it off the oral argument schedule. And then I also think that the court should consider the timing. Not every oral argument merits a 40-minute oral argument. So there's lots of courts around the country that will hear 10 or 11 oral arguments in a day, but each side is only afforded, maybe 10 minutes each. So that was sort of my proposal to the court, that we do something. I think that we're not giving attorneys an opportunity to sort of, even young attorneys, to develop those skills, as well as give the attorneys an opportunity to present their case orally. So my thoughts are that we sort of figure out a way to move forward with having more oral arguments. And so I guess I would put that out for discussion to the court.
I think we have seen a decline, and I think it's because, or at least coincides with, the court voting on oral arguments before the Chief Justice just did that. When we started putting it on the calendar for the court to vote on the motions. Seems like we declined more. But I would think in the alternative to what you suggested, we should just consider everybody that asks for oral argument is granted oral argument. Unless we start, and I don't think we're going to be overrun with requests, but I don't think we should make attorneys argue a case that they have not requested oral argument.
So maybe this comes from being, having spent so many years more recently arguing cases than anybody else. But my inclination for this is a lot of times you don't appreciate how complex a case is until you've actually spent the time prepping for oral argument. So I think on the front end, sometimes attorneys don't appreciate there are issues that maybe aren't fully explored in the briefs. That maybe you don't appreciate those issues until you're actually prepping for argument when you're spending hours preparing for it. So my inclination is sort of the polar opposite, that every single case should be submitted for oral argument. Maybe there are some that are not worth it once you actually conduct the review, but that's going to be a fairly limited number, because I think it gives both the advocates an opportunity to explore all the issues, which is, I think, very important, but it's also important for this court that they explore all the issues. The back and forth with counsel a lot of times will raise things that otherwise aren't noticed. And the default in a lot of other courts, particularly in the federal courts and the Eighth Circuit in particular, they will set every single case for oral argument. And then if everybody on the court agrees that it should be submitted without argument, they'll submit it. Again, that's the rarity. So I think there's a real value to the development of the law for holding oral argument in every single case. And as somebody who's argued a lot of cases recently, I think there's real value in that. I also, to Justice Wood's point, think it's important that the public see the court functioning. The public gets an opportunity to see how the court works, just as a civics matter, a constitutional matter. I think that's of critical importance. I also think that my own experience is, particularly with the criminal defendants, I doubt anybody would ever not want oral argument. They want their day in court. They're entitled to their day in court. Whether they win or lose, they're entitled to their day in court. The same thing is true for private litigants. And I think that gives them a sense of understanding the system does work, and that they've had fair, open-minded hearings. So I think that's also important. So my view on this is we ought to have oral argument in every single case, and I'm going to move pretty much in every case for oral argument.
I can't tell you the number of times we've been in chambers and said, man, I wish we had oral argument on this one. There was an issue that needed to be developed. And so I tend to agree with the idea that we need to have a significant increase in oral arguments. Although I do think maybe this is something that we need to communicate with the bar about. I think maybe a comment, I don't know if we want to do it formally, but I think they need a chance to weigh in too, because again, they're the ones coming before this court, just to be diligent and make sure that, we're not making decisions that has an impact that we're not thinking about with them. And so if we go down this road, I think we need to probably include them either in a formal way or in some way get some feedback related to this process.
My comment would be that oral argument can be a great advantage for educational purposes, for developing the law, for being able to ask questions that we need to ask. But my concern is that our docket as a Supreme Court has diminished in recent years. And I think part of that is expense. It's cost of hiring an attorney from the moment that you're at trial and moving through the various steps. So I am hesitant to put any more burden on parties to shoulder that expense. I spoke to an attorney recently, and he said, oh, yeah, oral argument can add $15,000 to my bill for the preparation and doing it. I didn't know it was that much, but from a private sense, I think that we need to be sensitive to the fact that sometimes parties are here with a very limited budget. And that they may not be able to pay an attorney to do oral argument, and that would be an onerous thing for them. So I think we should still leave that in the realm of them requesting it, and maybe this court being more liberal in granting them, since we have started voting on them, rather than the Chief Justice just deciding for him or herself. I think that we need to be, I mean, I like the idea that they request it, and point is taken, Justice Bronny, that we should be granting more of those. I mean, that makes a lot of sense. But I am hesitant to assign more expense to parties than they can or are willing or want to bear in the appellate process for just an oral argument that they may not deem necessary or helpful.
Also, we need to be mindful of the fact that it's going to be a significant burden on the public defenders. You say everybody wants their day in court, and I'm sure that's true, but need to be mindful of the fact that they have limited attorneys and they want to spend the time preparing for oral arguments on cases that they think merit oral argument. So,
I mean, I would say that based upon my experience dealing with public defenders and particularly the federal public defender, one, they don't lack resources. And two, they will be happy to accept oral arguments. They want to develop as lawyers and they want to make every argument for their client, and their client's entitled to that. I am sensitive to the fact, yes, it does add cost, as Justice Hudson points out. In my own experience, having done 30 or 40 of these, it is not that much of a significant add increase. But again, I think it's important for the development of the law for everyone, even if it is an increase in cost, that we get it right, we explore all the issues. Sometimes you don't see all the issues that could have effects on other future cases. And I think it's important to explore those issues. Again, there may be some that are not worth oral argument. It's going to be marginal, but this is the way other courts operate. The Eighth Circuit holds argument. The other federal courts of appeals hold argument. As Justice Wood pointed out, other state Supreme Courts do. I think it's important as part of the function of the court that we explore all the issues.
yes, when I first came on the court, we would have oral argument every time the court met, which was weekly, and we would frequently have more than one argument. And I don't have a problem with that. I think you're right. I think the court has a responsibility to help the bar develop as attorneys. So that's not my issue. But I think we need to be mindful of and consider what the public defenders think about this, what the bar thinks about it.
Well, my proposal was to draft something up and have it sent out, and we can have public comment on it. We can decide, at that point, whether it's an interim rule change or it's just a proposed rule for comments, but I'll work on a draft and circulate it around, and everybody can send me their comments if that's acceptable.
So just my two comments. Number one, to Justice Bronny, I think you'll find that the state public defenders probably have a few fewer resources maybe than the federal public defenders do. So it's a little bit different with folks in state court. But I think the balancing act here would be, if the default is going to be when you file a case with us, that it would be on a track for oral argument, giving the parties an opt-out versus an opt-in. So instead of having them file something and then make the argument that they want oral argument, file it with the understanding you're going to have it unless either the court declines or you ask us to not do it, or if both parties agree. I think we would probably tend to always, in most cases, allow a waiver. But yeah, I'm in favor of having a public comment period.
And Justice Wood is going to draft proposal, which is going to be that we will have every case on track for oral argument unless they opt out. Is that?
I'll draft a proposal and I don't know what will get 4 votes on the court. I think my initial proposal was some sort of period. It sounded like at least maybe there were 3 votes for that, is that the attorneys sort of let us know when they don't want oral argument, and there's a mechanism for the court to decide not to set oral argument. But there'd be a proposal for consideration, but, you know, there'll be options for everybody to sort of give their feedback before anything goes out to everyone.
If I can, one thing I'd add to that is like the federal courts do a time allocation. They can tell us what they think the appropriate amount of time would be. I think that's helpful.
All right.
Then we'll wait for a draft of the proposal. The next item is the vote on a schedule for spring budget hearings.
Yes, Justice Baker, I was hoping that maybe you had a plan, and if not, we could come up with a plan that sometimes it seems like we wait till the last second and we are sort of scrambling to all find dates because we all have really busy calendars.
Seems like in the last few years, we have been up to the wire on budget.
Yes, so I was hoping that maybe we could set more regular budget hearings and maybe try to come up with a schedule on the front end.
Does anybody have anything else to say about that?
I would just say maybe it makes sense to do it not all on one day, so we can focus and get a little more in depth. So pick the entities, bring 1 or 2 or however many that, you know, depending on how many employees and how big their budget is, so we can kind of focus on that. But I would recommend maybe we do it on Wednesdays before case conference days. That way we can kind of be here to work through it. And if there are any issues, everybody's still here the next day to kind of to follow up and so that would be my only comment. So, you know, I don't know if you're thinking March or April, but I would propose that we break it into sections and do it on Wednesdays prior to conference days.
That's fine with me.
I'm not sure you're on sound, Karen. I'm sorry.
Well, it's all
I
on.
said there's no sound when it's not green.
It is green.
It's right up top, so.
That change anything?
Hear it.
Well, if you push the function key to green. Okay. The mic goes off.
I think yours must be different.
I think it is different.
All
The default, and it's just on all the time.
So Justice Baker, will you send out some times, or do we need to hone in on a month on this so we can start coordinating calendars?
Would you think it would be better in the afternoons on Wednesday before our conference days?
Yeah, I think.
I mean, some of you are driving in from Springdale, Fayetteville. So,
Yeah, I think if we, you know, especially if we're not taking all of the entities on one day, I think we can do it Wednesday afternoons and, you know, kind of pack it in there. In terms of time of year, I would suggest probably that March to April window, because the fiscal year ends June 30th and we want to have time to react to anything that may pop up. So yeah, I would like this silent and
yeah, I would
suggest
think
maybe send out
maybe,
dates.
I suppose the middle of March, there's going to be a spring break in March.
We have a conference on March 20th.
The last week of March is spring break.
March 20th, we have a conference day.
So the 19th would be.
We have another one April 10th.
Spring break is the 24th through the 28th, so there would be after that conference date.
It said it was 3 Wednesdays.
The 3 Wednesdays starting in March, also it's March 19th. Okay.
What are those March 19th and?
The first 2 conference dates in April. We'll plan on that. If there's a need to have more, we can add more, but we'll plan on the first 2 conference dates in April, the Wednesday before, and starting March 19th.
So that's April 8th and 9th and 23rd?
Yep.
Mhm.
April 8th and 23rd.
Nine.
9th. Have you come there?
Nick's supposed to get the hazing.
So wonder where my donuts are now.
You graduated.
I was told it was the first case conference, not the first.
As long as you're number 7.
That's everything.
It was bagels.
Right.
Everybody send me their order and just tell me what you want.
All right, Supreme Court Employee Handbook and Training.
So, our Supreme Court Employee Handbook is outdated. If, I guess there are 4 of us that were here in 2019 when we, brought over, Missy McJunkins Duke from Cross Gunner at the time. I think she's with Rose now. And did, what year? 2019. Yeah, 2019, and we had sort of mandatory in the building training on harassment and conduct. And at that time, she recommended that we update our employee handbooks at the Supreme Court, and that failed to get past this court, and we failed to act on it. And we have a grievance in reference to some members of the court. It's clear the handbook does not cover it fully and how to act on those. And so we need to, as a court, I think, update the handbook. And I think that we need to have training again. And I don't know if there is someone in state government that regularly trains on those issues, or we need to bring in someone from outside to conduct another training on, professionalism and proper behavior and not violating the law, which seems ironic given we are the Supreme Court and we hear those cases. But so I think that, whether we want to assign, Kyle Burton to work and have someone in the clerk's office work on updating and proposals on the employee handbook, or we want to contract that out, which would be, a cost figure involved, and then how we want to move forward on training, which is just good practices. So that is why I asked for it to be on the agenda, so that we can, I think, act as a court should act.
We have a handbook that was created in, I think, the last century. So new employees are given that sometimes. I think, Courtney, you had the last employee that was hired, and they were not able to provide a handbook to her.
No, she, so apparently we have a document that you signed saying you received the employee handbook. And I don't know that she was offered one, but she requested one, and and Melanie, of course, kindly provided that to her. What I thought was interesting is it appears to have been written in 1999. So is that the same one that we're talking about? That, okay, yes. very likely needs to be updated and yes, and training to go with it. But I guess that's different than the AOC handbook, is that right?
Yeah, yes.
That's just, okay, got it.
Well, I was here when Missy Duke came and spoke and advised the court on policies and procedures concerning employee conduct and confidentiality and other matters that I think the handbook should cover. I'm not sure why that didn't happen. I guess it wasn't a priority, even though we did have training and we had people in. I think Kyle will have to be involved, Kyle and Melanie. And does anybody want to particularly work on that issue? No? Nobody's.
Yeah,
I
I
would be
mean,
involved in it.
I'm happy to work on it. I've done employment law in the past, although I'm gonna need an update too.
Yeah.
But I know that when AG Griffin came in, he updated all the manuals over at the AG's office. So there is some, yeah, there are reference materials from other state agencies and just like Googling through. I mean, it looks like most state agencies have them that were updated in like 24, 23, 22. So if we're last century, we're way behind. So, but I'm happy to take on part of the labor and order there.
All right.
Then I guess I'd motion that we update the employee handbook and that our newest justice, welcome number 7, kind of lead that effort. And then once it's, I guess, updated, then we bring in and have someone do training on it. So that would be my motion.
Second.
All in favor? All right, motion carries. Next, Justice Brawny has Appeals on Wheels.
So I know in this fall and spring or thereabouts roughly, the court has historically done appeals on wheels. I'd asked the clerk's office whether there was one scheduled for this year. It sounded like there wasn't. So I looked, I had my law clerks look to see when the last one in South Arkansas has been, which is where I'm from. And it's been a long time since there was a South Arkansas one. So I was going to throw out the suggestion of Camden, which is my hometown. But there are other South Arkansas locations. It's my understanding that maybe Magnolia had expressed some interest as well, even the SAU campus. But recognizing what the calendar is, I wanted to raise that soon so that if we were going to put something on the calendar, we can do it sooner rather than later.
We do need to schedule it, and I had a request that it not be 1 week in April. There was a week in April that they were asking not schedule it that week, and I don't think I have that email.
Yeah, I think there was somebody getting married that week, as I recall.
Yeah. He was, someone was going to be out in the clerk's office and it would be difficult for him. But we've done Appeals on Wheels for a while, so one in the spring, one in the fall, and I agree that we should. I'm sorry, there's a second, I didn't.
And I was going to say that, so I do know that the campus, it was former Representative Leanna Birch, and that campus on Magnolia had asked like 1.5 years ago. They've been kind of on the waiting list to do that. So, and it may be that if, and we do try to go to justices, give them, if they want to go. So I don't know if, the clerk's office wants to reach out, and it may be that, if we want to go, they're okay, depending on their school schedule. If Camden, we go to Camden in spring and then we line up Magnolia in the fall, or vice versa, but we line up that, if there's nobody else next, I don't know if that Karen, if there's somebody else that is in line, but I do know that they've been in line for a
For a
while. But then I think Camden's a great choice too.
Thanks for handling this.
Yeah.
I
think that's
wanted
right.
to also address the cost of Appeals on Wheels. When we started, and I'm just going from 2011, we spent a total for fiscal year 2012, a total of $1,046.81 on Appeals on Wheels. And and of course, the price has gone up, but this last year, we've spent 13,000 on Appeals on Wheels in Mountain View and 12,800 on Appeals on Wheels in the fall. And I think that that's largely attributable to the increase in people taking their staff. And the court used to have a rule that the main and the backup on the case that was being argued could take one employee, could take the clerk that was assigned on that case. Now it seems that, and that was pretty much it. We had a couple of people working security, and other than that, people didn't take their staff. And I've noticed in the last couple of years, I don't know when this changed, but they started taking, since we started doing Appeals on Wheels, we didn't spend a lot when we went to Bryant. Most people were able to get there, and we weren't having much hotel expense, but I can't see spending $25,000 a year, mainly on staff traveling with the court. And I don't think we need that much attendance to the justices. So I would suggest that we return to the rule that the main and the backup on the case can take one clerk. Otherwise, we don't need staff.
So is your suggestion that just in terms of paying for staff, I mean, staff could go on their own and attend, but not have hotel paid for out of the Supreme Court coffers?
Well, sure, if they wanted to drive to Camden or Magnolia, that's fine. If they want to stay overnight at Camden and Magnolia, that would be at their own expense.
I'd sort of like to see some of the figures on that and look at that and kind of see how that goes. So I guess I'd motion that we sort of table that issue and look at some of the costs on that.
I'm fine with that. The one thing I would add is if, my understanding from having attended these in the past is the court often goes down to meet with the local bar members, et cetera. I think that's important, but if that's part of the expense of the hotel rooms, I can drive Magnolia or Camden same day. Like, that's not an issue. I know for other members of the court who are a little bit further Northwest Arkansas, that's probably more problematic, but certainly for me here in Little Rock, that's relatively simple anywhere in the state.
Well, in Mountain View and Fayetteville this last time, of course, the law school is able to host. There's no problem with that. For the event of a reception when we get there, I know sometimes it's a burden on the local bar to provide that. And when we get there and I look across the room and see mostly our staff in attendance and not so much the local bar, that's a problem.
Just to figure out, I mean, I agree, that seems awfully high. I guess you've got a motion. I would second that just to see what proportion. Let's make sure we're addressing whatever the issue is. And if it is staff, then that'll give us a chance to, fix that. I mean, it could be, I just don't know what the numbers are. So if we could see the numbers, that would be great.
So is the motion to request a breakdown of what the expenses have been for the last few appeals on wheels, so we kind of know, is this just like a natural increase in hotel prices and things of that nature, or is it just attributable, as Justice Baker said, to staff and taking more staff than previously had gone?
Yes, so I think that all of us want to be fiscally responsible. So to pinpoint sort of where the cost is coming in, is it coming in with meals, receptions, hotel, inflation? So, let's look at all the numbers and then come back as a court and do what, is the responsible thing is. So my motion is, table whatever this discussion is so that we have the benefit of whatever Justice Baker has. Information and look at it.
Well, I would agree with your motion, but I also would like to say that just the feedback I got from Benton and Bryant, and in that case, they hosted the reception at their expense. And they enjoy, and we had a big crowd from the community show. We had a lot of elected officials, we had parents, we had just a lot of people that came. And so maybe we can look at that on an individual location basis, if there's a group willing to host on something like that. And also I try to tie into that an opportunity to visit with a class at the local elementary school and things like that. So I think it's an outreach of the court. I think it's a real good opportunity for people to see us, what we do and talk about what we do, whether it's to a classroom or whether it's at the actual oral argument so I would hope that we would consider there is a value to this, so.
Absolutely, and I'm not suggesting we don't do appeals on wheels. I am suggesting that we not take
Right.
7 AAs and people
I understand.
from the AOC and
Well, and I know we tried to keep the expenses down in Bryant and Benton, and we did, so.
yeah, you did.
Okay.
I think it was less expensive. It was less expensive when we did Conway because there were less hotel expense. And that's what it mainly is hotel expense for staff.
And just to be clear, I don't think, or at least I'm not aware of us having ever paid for a reception. I think that's always hosted by either the local bar, Chamber of Commerce, college, law school.
It is. Yes, the court doesn't pay for that, but and we don't usually go without an invitation, so they're expecting to do the reception. All right, so the motion is to table that matter.
And if you want to go to Camden, have them send us your life.
Yeah, or if Magnolia's been on the waiting list for more than a year, that's.
It's a while.
If we want to vote on the first motion, I guess we can also decide if we want to. I guess
where
motion on the
where we
two
want to go.
places.
No, I was not the keeper of the waiting list, so I'm not sure how long they've been on the waiting list, but we'll see about that. So that matter is tabled till the next business meeting. Are you going to vote to table? Motion to table?
Motion to request breakup, right?
And the table.
And the table of decision otherwise.
On the, yeah.
Have you seconded? I'll second.
All in favor?
Aye.
All right. Motion carries for appeals on wheels
Justice Baker, are we just going to vote on the location?
at the time. I think we might need to decide before that.
It may,
I'll just reach out to Camden and Magnolia and.
See maybe if he's prepared or able to.
And they're all, I mean, it's all relatively close. So if we did one in Magnolia or Camden, El Dorado, Camden, Magnolia, Smackover, et cetera, the schools could certainly, if they were
Get the
interested.
schools to
Yeah.
bring to one location.
You potentially have one host the reception back before and the other host the argument. For the day of. It's a good idea.
So combining Camden and Magnolia is,
I guess I just make a motion that we reach out to Magnolia and Camden, and after we find out who would be interested, if Magnolia is still interested, we could go forward with that. If Camden's also interested, we can work with the two, but at least let's reach out to them, given the schedule.
all right,
Is that a motion?
is that in the form of a motion?
I move we reach out to Magnolia and Camden about potentially holding Appeals on Wheels down there.
I'll say.
All in favor? And the motion carries. Next, we have a report on votes from January 6th business meeting.
So I asked to have it on the agenda, just to update, since Justice Hudson and Baker were not able to be there, the meeting on January 6th to go over the items on there. Some of it has already been reported out to the court. The first was the proposal submitted in writing to the court by Justice Womack about the court liaison change. There was discussion on that, and the motion was by Justice Webb to approve, second by Justice Hyland. It passed with 5 votes, 2 not participating. And the action was Justice Womack to circulate the newly passed language to the court, which he has. And of course, the proposal had been submitted to the whole court. Second item was Administrative Order 16. That issue was presented by me, Justice Wood, with a call to considering changes to Administrative Order, because with 16, again, that was because of discussions throughout Arkansas with members of the bar and the judiciary, and to return to make it consistent with the Constitution on judges sitting on exchange, and return to what had been the past rule and protocol. There's discussion, motion by Justice Womack to approve, second by Justice Hyland, passed 5 votes, 2 non-participating. The action was Justice Wood to prepare a per curiam for the court. Of course, I have prepared that per curiam that is circulated to the court and been voted on. The third was the carpet update, discussion on the status and the cost. The court had discussed that it was becoming financially unfeasible, and to try to look into the feasibility of that. And so there was no action taken. Fourth was the confidentiality of proceedings and recording proceedings. The proposal was to reaffirm the written rules and the internal procedures of this court has always been that all proceedings of the court, all business meetings are confidential. And that has been the longstanding tradition and policy used by the court, and that the court had actually voted on that prior to the Justice Webb and Hyland and Brawny joining the court, and that the others of us had signed a statement to that effect on confidentiality. So the discussion was to, again, prepare a written rule in order that Justice Womack would prepare and refer violations for violating confidentiality to OPC, JDDC, and make it contemptible. There was a motion by Justice Womack, second by Justice Hyland, passed by 5, 2 non-participating. The action is Justice Womack will prepare a per curiam for the court. Fifth was a SharePoint protocol reminder by Justice Wood that she has operated since for about 11 years, sort of administering SharePoint. I, as Justice Wood, requested reaffirmation of the court's letting her do this role. Discussion of this press protocol, motion by Justice Hyland, second by Justice Womack for Justice Wood to continue in that, passed 5-0. Action is that I would begin the periodic audit that I do with CIS. As an update, I've begun that audit and notified, included the Chief Justice in that. And all of you should have been notified by my office to make sure that you had the proper people in your SharePoint access. 6 was the district court per curiam. Justice Womack presented that the previous court's proposal on that did not get out. Discussion, no formal motion was made. The action, though, was Justice Womack would recirculate that to the court. That occurred, and I believe that's been handed down with a unanimous court. 7th was the JDDC appointments. Discussion on that. Motion by Justice Womack, second by Justice Brawny, passed by 5, 2 non-participating. Motion to hand that down that day by Justice Womack, second by Justice Hyland, passed by 5, 2 non-participating. And that was the vote of the court. So that is the update from the business meeting that Justice Baker and Justice Hudson were not able to attend.
All right, well, thank you for providing that update. And I would like to say to the court, off to a rocky start, but I hope the situation will improve. But I do not recognize anything that was done at that meeting because I did not call the court into session. We were in recess. And I believe it was something like 8:30 on a Saturday night by email that there was a motion by Justice Womack for the meeting. I had a doctor's appointment. The motion was for the court to meet at noon. I had a doctor's appointment out of town that had been previously scheduled for 2 months. I don't think that anything that the court, any business that the court had couldn't wait until today. And said so at the time, recognized Justice Womack's motion as a motion for a business meeting and said that we would have a business meeting on this day because all of the cases that we had scheduled, not that there were that many, there were 3, Justice Brawny had to recuse on, and so we were left with the court date open. Yes, and a per curiam was handed down that I think was inappropriate. I think it's inappropriate to hand any per curiam down without the whole court's agreement. That's what per curiam means. And I have gotten a lot of questions about what does per curiam mean. And I think it's unfortunate that the court then proceeded with attempting to hold a business meeting. But this is the first business meeting that I recognize. And I believe there's been discussion about what the duties of the Chief Justice are under the Constitution in Amendment 80. I think it's clear that the court's Chief Justice administers the court, and I filed an order stating what that means. So,
Well, I guess since we're all able to just not recognize the actions of others, I wouldn't recognize your order that you filed, but I mean, part of the reason that there was a necessity to act fairly quickly is because 15 minutes after midnight on January 1st, when you were sworn in, you unilaterally appointed 3 members to the Judicial Discipline Commission, Discipline and Disabilities Commission, which seemed quite odd because the court makes those appointments. And so, I think that was something that was fairly urgent to address. It seemed odd that, you were doing that so urgently right after you were sworn in, including one member who was clearly not eligible because he had retired as a judge and it required a judge to be appointed in that position, as I understand. So, but I would just note that although you say you don't recognize it, you joined several of the things that were voted on that day. So eventually when they were circulated. So, I think somewhere between a third and half of this list has already been addressed and enacted. So anyway, that's my comment.
I guess that I don't agree with your interpretation, but just as a backup then, even though I don't agree with your interpretation, as Justice Womack said, some of these have already gone into effect, that then I make a motion that the court readopt items 1 through 7 as I just specifically read.
So to ratify the actions of January 6th. Yes. And I would ask for an amendment to your motion that it be ratified retroactively to January 6th. So any action taken that day has no question as to its effectiveness.
I recognize that as a friendly amendment.
And I would just point out that I've served on this court since 2021. And it's been my understanding and the practice of this court while I've been here that these decisions are made by the court. And I believe that's what Amendment 80 says. And so I think a majority of the court is where these decisions have to be made based on the Constitution. And so that's just my comment. And so I would be in favor of the motion.
This is my 15th year on the court, Barbara, and I agree that it says that the court makes these appointments, and that has always been the full court. That has not been a majority of the court. It has been the full court, and so it would be a large change in practice and tradition of this court to do anything but have everyone around this table be unanimous on those very important appointments. And so I think that we should put ourselves aside and think of the greater good here in terms of the institution being bigger than us, and find a way to continue making appointments that are acceptable to everyone. There are thousands of attorneys in Arkansas, hundreds of judges. A lot of people can serve in these positions. So it should not be difficult to find great people to serve who are acceptable to everyone around the table.
Well, just to clarify, I was talking in terms of all the action that was taken, not just the appointments. But I agree with you on the appointments. That has been the practice of the full court making that decision and respecting if someone has a concern. So.
Well, I've been on the court since 2011. And I believe Justice Hannah made the appointments and did not consult the court about it. I don't have any problem, and I said I didn't have any problem with appointing some of the members and changing some of the members. But I think the Chief Justice does have the authority to make the appointments and, so we have a problem with the interpretation of Amendment 80.
Can you elaborate on?
I'd like to call for a vote on the motion.
I think I'd probably prefer we do discussion on this point first.
Can you elaborate on where in Amendment 80, since that's what you cited, that you think it gives you the appointment to unilaterally appoint members to the Judicial Discipline and Disabilities Commission?
I think the Chief Justice administers under Amendment 80 the functions of the court.
So your position is that the language in Amendment 80, which I assume you're talking about Amendment 80, Section 4, is just unlimited to anything that the court could do, you could do instead of the court?
Yeah.
Okay.
Functions for the court, yes.
Okay. First of all, I think you're clearly wrong on that. Second of all,
What do you think the Chief
we've adopted, but.
What do you think the Chief Justice is able to do?
But I think, and I can get you a list. I have a list of things that are either constitutionally or statutorily delegated to the chief, and some things that are constitutionally or statutorily delegated to the court. And I think where it says the court, that's the court, which requires a majority of the court. So whether it's you or John Dan Kemp or Howard Brill or Chief Justice Hannah, I mean, I don't think any of the previous chiefs in my interaction with government going, I guess since we're all going to talk about how long we've been here, it's my 9th year on the court, but 26th year, 27th year in state government. I can't remember a time when a chief has asserted that they had unlimited power to be the court, which apparently is what you're asserting here. Certainly there are things that are delegated and reserved for the chief, but I don't see anywhere that that's just an unlimited blanket power. And as the only person in this room that was on the House committee that passed out the resolution that eventually became Amendment 80, I can assure you we didn't, and we had several hearings on it. I can assure you we didn't spend a second talking about whether or not the Chief Justice was the only one that had the authority to call a meeting, or if the Chief Justice could make appointments to things that otherwise were to be appointed by the court. I think you are grossly overreaching with your interpretation of Amendment 80. But having said that, no one is trying to take away from you any powers that are delegated to the chief. And so, I know we've got a motion that we need to vote on, but at some point, I think it would be worthy for us to circle back and talk about this appointment process that you think you have. And so.
Can I ask, just as a clarifying question then, is it your position that section 1610-402 is unconstitutional, a duly passed statute by the legislature?
That statute?
Yes.
No, I'm not alleging it's unconstitutional.
So you don't think that the language which allows the court to make those appointments is unconstitutional, but you think Amendment 80 confers that power on you? I'm somewhat confused. Can you help clarify?
I think that Amendment 80 confers the power to administer the functions of the court.
Well,
These
Karen-
functions are administered by the Chief Justice.
but Karen, in response to, I guess, Justice Bronny's question, if you think that statute's constitutional, you have written opinion after opinion that the more specific language trumps the general, and that when the legislature uses a specific term, it means something different than the general term. So in one provision of the statute, it says the Supreme Court makes the appointments. And then in another provision, it says the Chief Justice. So you have written opinions saying when they specifically use different language in the same statute, it means different things. So if that statute's unconstitutional, then explain to us how it didn't mean different things in that context.
I think Amendment 80 confers upon the Chief Justice the ability to and the responsibility to administer the functions of the Supreme Court.
You're not answering the question.
I think I am.
So maybe this will help if I can, I'll narrow down to the language of the statute here where it says, referring to JDC members shall be judges of the Arkansas Court of Appeals, Circuit Court, or Municipal Court appointed by the Arkansas Supreme Court. You read the term Arkansas Supreme Court to mean you and you alone.
I read the term to mean the Chief Justice administering the Chief Justice administering the function of the court.
He's still.
Oh, I'm
Sorry.
me.
Where is that in the statute?
It's in the Constitution.
I'm asking where it is in the statute. If you believe that the statute conflicts with the Constitution, that's a slightly different argument, but where is it in the statute?
I'm not prepared to answer where in the statute.
So is that an answer? You now don't know whether the statute is constitutional and you need to decide on that? I'm confused.
I'm interpreting the statute in a way that would be consistent with Amendment 80 and the Constitution.
Sorry, I think that's still non-responsive to my question. Where in the statute does it say the Chief Justice alone makes those appointments?
It doesn't say it in the statute. It says the Supreme Court. And Amendment 80 says the Chief Justice administers the functions of the Supreme Court.
So can I ask what the limitation on that is? What is the limitation on your view of Amendment 80? What function is it that we perform that you can't just unilaterally perform? I just want to make sure I understand the limitation here.
I don't know that it is limited by the Constitution.
Well, I would read the Constitution to you. The Supreme Court shall exercise general superintending control over all courts of the state, not the Chief Justice, the Supreme Court, and may temporarily assign judges with their consent to courts or divisions other than that for which they were elected or appointed. These functions, the assignment of judges to shall be administered by the Chief Justice. So that's the way I would interpret the Constitution.
Justice Baker, the limitation question by Justice Bronte is a good one. My question is, can you terminate my clerks,
No,
my AE?
I don't think so, no.
Okay, but that's a limitation. Based on your argument, why wouldn't it extend to that? Why wouldn't you extrapolate that to that kind of authority?
Because I would say that I think we operate on custom and practice. And the custom and practice of the court has always been that each individual justice may hire their clerks and oversee their clerks and their administrative assistant.
No, I understand the custom and practice, but based on your argument, couldn't you go in and just terminate everybody? Because you're the end all be all related to Chief Justice and the administration of this court? If you wanted to, couldn't you? Set aside practice. Isn't that what you're arguing?
No,
Okay, so where's the limitation? Just practice?
yes,
So just your graciousness. You're being gracious.
it's also been the custom and practice that the Chief Justice administers the functions of the court in compliance with the Constitution. I don't think that's a function of the court.
But, okay.
Okay, Justice Baker, can you give me an instance where the Chief Justice, if custom and practice is the case, then it has been the custom and practice I served with the same three justices, the chief justices you've served at. I've sat here and you voted with me, 4 of the justices on this court terminated a Supreme Court employee over the objection of a chief justice. The Communication Council over the objection of Chief Justice Hannah. You voted with that. So you believed at the time, under Amendment 80, that you included, the 4 of us could override the vote of the Chief Justice to terminate someone that was a Supreme Court employee. So you believe the court as a whole and 4 justices had that power over the authority of the Chief Justice Hannah. And you voted with that, correct?
Yes.
So how Amendment 80 has not changed since then, correct?
Amendment 80 hasn't changed
Okay,
since
so if you,
2000.
so if you're just responding to Justice Hyland, that the limitations are custom and practice, the custom and practice has been that it's 4 votes to terminate employees. And that you have actually voted with that.
I don't recall that Chief Justice Hannah voted against that. That is not my recollection, Justice Wood.
Can I then raise to Justice Hudson's point about the appointments to JDDCs normally being unanimous? That was the custom and practice of the court. Yet 15 minutes after midnight, you unilaterally appointed 3 people without notifying any members of this court that you were appointing them. And can you explain how that was consistent with custom and practice, or is that just based on your interpretation of Amendment 80?
It was based on my interpretation of Amendment 80. But I don't know, this court abandoned custom and practice before you joined Justice Bronny, and I would like to get back to that. It started with per curiam opinions that are not the full court. And it started with a per curiam opinion that referred Justice Hudson to JDDC without the full court. And with me not even being notified that it was being considered. So
Justice
based
Baker,
on that and Justice Kemp's unilateral appointment of people.
So I guess I just want to make sure a lot of what you just referred to happened obviously before I was here. So I don't know the in-depths of all of that, but I'm just, so is it your position now that custom and practice, you couldn't do what you did under Amendment 80 at the stroke of midnight? Or I'm just confused what your
The
position
stroke
is.
of midnight doesn't really matter, does it? It was after I was sworn in.
I mean, it mattered to you if you did it, your first official act as Chief Justice, so far as I can tell, but I'm trying to figure out, you said custom and practice is a limitation, yet you didn't act consistently with your own interpretation of custom and practice. So I'm trying to figure out what those limits are. You know, I have no problem with you administering the general functions of the court. I think, for example, closing the court for a snow day, I think that's perfectly appropriate. Somebody needs to be the head, the first among equals to do stuff like that, make those decisions. I absolutely agree. That was within your prerogative to do. But I'm trying to figure out on some of these other issues what the limitation principle is, because as I read the Constitution, all members of the court are equal. You're the first among equals, but we all have a
On
voice.
cases.
I think that's where we would disagree. I don't know where the language you're pointing to in the Constitution that says that, other than you say generally administer the functions. And I think if we analogize this to the federal context, where the Supreme Court Chief Justice Roberts, his functions are clearly defined in statute because there's vague language as to what the Chief Justice does. So that's why I was asking about a specific statute that says the way things operate. I would think that your role is defined by statute when the Constitution itself is vague, and we should defer to the legislature in making those kinds of decisions. But I take your position to be we don't defer to the legislature. Instead, it's custom and practice, but maybe sometimes, but not other times. I'm confused as to where the limitation is.
I think we need to define for the court, those limitations.
Justice Chief, if I may, obviously, there's a lot of disagreement around the table about, Amendment 80 and the court's duties, the Chief Justice's duties. And in regard specifically to this JDDC appointment issue that we're dealing with, even though we disagree around the table about some of this, would you be willing to make custom and practice of appointing, whether it's JDDC or court automation or whatever those appointments are, would you be willing to concede or to delegate those duties to a full court?
Yes.
To make those appointments moving forward
Yes.
or, okay, so as long as the entire court is in agreement,
Yes,
you would, okay. Now, I think that reaches the same place as if this court is in agreement for those appointments and it says the court, that we get to that result, even though there may be some disagreements.
Well, Justice Hudson, I think you even said that you thought the Supreme Court as a whole made those JDDC appointments, did you not? So really, there's one disagreement, and that's you. And so the question is, are my employees, my clerks, my AA, are they only surviving because of your benevolence as custom and practice dictates, which you've already proven you're willing to break because you made those JDDC appointments? So as far as acquiescing, I'm not going to acquiesce a clear constitutional provision that gives the court the ability to make a JDDC appointment. I didn't write it. That is what it is. And so this idea, and Justice Bronny's point is one that's well taken. I would like to know from you what you think your limitations are in the administration of this system pursuant to Amendment 80, because right now I'm not seeing many.
I don't think there are many.
Okay.
What I understand is 6 justices around the table do not believe you have the sole authority to make appointments for the court as an administrator. So that is 6 of your colleagues.
Anywhere,
Yeah, so that's 6 of your colleagues telling you that.
anywhere?
Yeah, so
You're saying
I'm telling you
anywhere.
that. So I'm telling you that.
Any appointments to anything?
I think unless there's a specific, I think there are some statutes, there are some commissions that were created by the legislature that give the Chief Justice authority. But I'm saying that, for instance, like JDDC, there's a statute that has specific provisions. But you're hearing from 6 of us that when the reference is that the Supreme Court acts for appointments, that we're telling you, we do not believe that means the Chief Justice acts for those appointments. And then secondly, you keep saying per curiam, that should be unanimous.
Yes.
And so are you telling us that you have never concurred or dissented from a per curiam in your time on this court,
No,
ever?
I'm not doing that. I don't think that I have as to appointments.
That's not the question. You've stated that per curiam should mean per the court. That's what it means, and that should be unanimous by the court. But in fact, you have not joined per curiams, correct? Repeatedly.
Repeatedly. Administrative per curiams.
And I guess my follow-up question is, if you have sole authority to act as the court under Administrative 80, which is what you've told Justices Bronny and Highland, why are you even setting a business meeting? Because you've set a business meeting and you're asking for votes, but you've told us you're the court.
Yes, I want to get a sense of what the court wants to do. I want to proceed with the custom and practice. There have been times, and I haven't looked them up, but it used to be a common practice that, or not common, but it was a practice that there were per curiams handed down that were not the whole court. And that there were per curiams with dissents in post-conviction cases.
Can I clarify a response is it your suggestion that when we take a vote in this business meeting, that you can just decide unilaterally to go the other way if a vote is 6-1, 5-2? Is that, you believe you have that ability pursuant to Amendment 80?
On what?
Administrative decisions that we've made today, that we've made motions, we've seconded, we voted, in some cases, unanimously. But is it your position that Amendment 80 gives you the ability to come back and unilaterally disregard a vote of this court?
No. No, because the custom and practice is to get the sense of the court. For instance, on oral arguments. The court never voted on oral arguments. At one time, they were handled solely by the Chief Justice.
Justice Baker, I'm not asking about custom and practice. I'm asking about what your interpretation of your authority under Amendment 80 is related to administrative matters of this court. I'm not talking about custom and practice, benevolence. I'm asking about what you believe, and it's important for this court to know.
It is.
I need to know
It
what you
is.
believe so when we make decisions as a court, can you come back and unilaterally disregard a decision of this court in an administrative matter?
In administrative,
Absent a constitutional or statutory delegated authority to you.
yes, I believe so.
Okay, thank you.
I believe so. And the way that that's presented, having a little bit of trouble.
Well,
Do you believe?
well, I'm not
Do
trying
you
to trick.
believe as individual justices that you can outvote an administrative decision of the chief?
Yes.
That's your
Yes.
position.
Absolutely. Yes.
I would
That-
motion we
absent
call.
Specific delegated authority.
Let me talk before you get us to the motion. So there's been discussion about the statute, but let's just look at the Constitution. I have issues with Amendment 66. I think after Amendment 80, Amendment 66 is invalid. But the majority of the court has not gone there yet. So if we look at Amendment 66 in the Constitution, it says with respect to JDDC, 3 justices or judges appointed by the Supreme Court. So I guess we could look at Amendment 80, Section 4, and look at that word, those words, these functions shall be administered by the Chief Justice. I would make the argument in that type of context, we as a court vote to make an appointment and maybe you communicate. That's the administrative part. You have a ministerial function as the Chief Justice to maybe communicate what action the court has taken. But to the extent that this court has not yet stricken Amendment 66, that language gives the power to appoint to the court, not to the chief. And I think that's unequivocal. I want to go back to the appointments though. When were you sworn in?
I was sworn in a little after midnight.
Okay. So you were sworn in when you made the 3 unilateral appointments.
Yes.
Okay. So part of the reason I guess you felt there were vacancies is because after a couple of months of trying to appoint people, There have been holds including, I believe, by you. And I'm curious, was that done intentionally so that you could make that your very first action as Chief Justice, was to try to get control of the commission that was investigating you? Pick your own jury, so to speak?
Well, they're investigating the whole court, aren't they? And
I don't know that that's, just for the record, I want to make clear, I don't think that that's accurate.
not just.
I'm new.
Hang around.
Yeah, I think,
Just wait.
I think some of that may be more meritorious than others, but to Justice Hyland's point, let's say it's not our individual office staff. Do you think you have the authority to fire the Supreme Court clerk or people that work in that office?
I don't, because Amendment 80 says that the Supreme Court shall choose its clerk.
But you just said
And
that everywhere it
order.
says the Supreme Court, that really means you, and it doesn't, the rest of us are irrelevant. So why, if it says the Supreme Court shall appoint members to JDDC, that doesn't mean anything, but if it says the Supreme Court shall choose its own clerk, that does mean something. What's the difference in your interpretation of your powers there? Do what? It's on.
When you finish talking.
What's the difference in the limitations?
Right. Just to clarify, you just said that you don't think you could fire the Supreme Court clerk because the Constitution says the Supreme Court hires the clerk.
Right.
But you do think you can unilaterally appoint members to JDDC when it says the Supreme Court shall appoint. So in one context with the same language, you're saying that the rest of us are irrelevant and you get to choose no matter what we say. And in the other context, you said, well, maybe you don't, even though it's the same language.
Yeah, I should have been prepared to address this. But I think essentially that I did address it in my administrative order. You're sort of picking your own jury as well. And it's custom and practice that the Chief Justice has made those appointments.
So I'm going to get
But
to, I'm going to get to custom and practice in a minute, but let's move on from the actual clerk. Let's look at the employees in the clerk's office. So someone that processes briefs being filed, can you fire that person?
I think so, yes.
Okay.
Somebody needs to have that authority, yes.
So you don't think the clerk that the court has hired has that authority? You think you have that authority to go beyond the supervisor and do it without the rest of the court speaking?
I'm not sure. You're talking about the clerk's employees?
Yes.
Certainly the clerk has supervisory authority over them.
But do you?
Yes, I think so.
So let's talk about custom and practice. When I got on the court, there was much disdain about some of the previous members expressed by you and others. You're telling us what you remember as the custom and practice because you happen to be here a couple of years before some of the others, but I took an oath to the Constitution. I feel like I'm bound to the Constitution, then the statutes and the rules. And I'm not bound to custom and practice anywhere that I'm aware of. And just because Don Corbin decided this is how we're going to do something, that has zero bearing on how I decide or you decide or any other member of this court decides we're going to do something now. But apparently custom and practice changes because going into my 9th year now, you're saying that, okay, well, before Chief Justice Kemp was the chief, the previous chiefs just got to make these appointments and didn't deal with the court. But
I think she does.
The custom and practice during my entire tenure on the court has been that the court has always addressed that as a whole. So which custom and practice do we look at?
It'd be great if the court could address it as a whole. I don't understand why the court has been functioning as if there are only 5 members.
Because the chief has been functioning as if there was only one. But, you know, I don't think that we've unilaterally done things individually. I mean, in my experience, no individual member of the court has ever filed an order on their own, but you filed 3 that you hand file marked at 15, 20, and 25 minutes after midnight, and then gave to the clerk the next day. An order from Justice Karen Baker, and then I think your later order was an order from Justice Karen Baker. I've never seen an individual justice outside of a dissent or a concurring opinion just do that. Custom and practice. Let's look at the dissent on Justice Hudson's case. That dissent was handed down later without ever being circulated to the members of the court. The first time I found about it was on social media.
Well,
And so that certainly isn't custom and practice. So again, I don't feel like we're bound by custom and
Have you
practice.
ever
I
seen a
think we
case-
determine custom and practice
Yeah.
as we go. But we're bound by certain things. But you're talking about custom and practice as if it's this glue that holds us together, but yet you're all over the place on custom and practice. And you're doing things that the 4 previous chiefs that I know never did.
I would ask that we not discuss a procurement, a case that Justice Hudson and Justice Bronny, so I'd ask we not discuss that if we could, not participate in. But eventually I'd like to get back to a vote on the motion, but what I'd like to say,
I'm not sure what the motion is.
yeah, well, it's that we ratify retroactively all 7 items as I read them that we voted on January 6th, and there was a second on that. But what I would like to say, Justice Baker, is that all of us on this court in good faith want to work with you and wanted to work with you. And, but having worked with the 3 chief justices that you worked with, what I can say is that none of those 3 justices signed orders and made those appointments like that. And then none of those 3 justices would have fired outstanding employees that would have ground the entire state system to a halt without even notifying a member of the court. You know, it cannot go unsaid that those are some of the finest employees that have ever served the state of Arkansas. Many of them have been here decades. They work weekends, nights. The members of this court call these people at, you know, all kinds of hours. They give up their family time. They are interrupted round the clock. They basically are never not at work. We walk over across here and we see the Civic Education Center that is going to live for generations, that all of Arkansas is going to appreciate this amazing history. And that would not be here without Marty Sullivan. And I would love to know how much interaction you had on that being built, because I can tell you, he was over here nonstop, weekends, Sundays, giving up family time to see this for the benefit of the state of Arkansas. And it is immeasurable. We will never, there is no financial dollar, no thank you, no anything that anyone in the state of Arkansas can ever do. And the unbelievable, and I know how many times we have called and asked him to drop everything to do thing. And every member of this court has done that. And that is undeniable. The amount of work that we have him do and sacrifice for his family. And it is absolutely imaginable that the unprofessionalism that he was treated and for his family, and that would occur, and no justice has ever treated someone that way. And so we, in all good faith, we're ready to work with you. We want you to lead. We don't want to do your job. You know, we are happy. I'll be honest, like, sure, Barbara probably the same way. Sure, there's a little bit of like, you know, no, didn't win the election. But then after that, it's like, great, my life's going to be easier now. But guess what? It's not, you know. But I will say this, Marty Sullivan is the most amazing man on earth and thankless hours. And so, but for him to be terminated in that manner and all these employees, it's like, that is not Chief Justice behavior. And so for you to say, I want to come to the table and work with you, we want to come to the table and work with you. And we want to do that constitutionally. But we will not stand to let these employees be treated that way. And an apology is due to all of those employees at some point. So with that being said, at some point, I think that we need to like, you know, move on and do what's best for the court. But it's just unbelievable.
I guess I'd like to ask, just for my understanding, and we tried to talk to you about this the day that you attempted to terminate these folks, but ACA 1610-102 A2 talks about the AOC director. And it says, subject to the approval of Supreme Court and Arkansas Judicial Council, subject to the appointment, the director shall hold office at the pleasure of the Supreme Court. Now, you have made the argument that the Supreme Court is you administratively as it relates to those JDDC appointments. Is it your position that 1610-102 is unconstitutional because of Amendment 80? Is it in conflict with Amendment 80?
I don't think it is.
May
Okay.
I say, I just don't know that it is fair or appropriate for us to have this conversation with Marty in the room.
I'd like to say I don't really care because we're live streaming it with all due
I
respect.
know, well, I just did, but to put you on, I mean, I just,
I'm fine.
Okay.
Well, I mean, so you don't think that that statute is unconstitutional or in conflict with Amendment 80?
No.
Okay, but it gives clear, it's clear. It gives, they serve at the pleasure of the Supreme Court. And so let me ask you this question.
What does it say?
Let me ask you this. If you're hiring, let's say there is a vacancy, obviously you get to nominate, and the statute says that the court confirms and the Judicial Council confirms. Would you feel like you had to seek approval of the court and Judicial Council in making that hire?
Yes.
Okay, but you don't think but you attempted to terminate him without the approval of the Supreme Court. You did that unilaterally. Right?
I think I have the authority to do that.
Based on what? Justice Baker?
I don't, a lot of these matters are currently either in JDDC investigations or are currently going into litigation. So
There were 10 employees that, from what I understand, exceptional people. I've been here a year and a half. Had great experiences with all of them that you attempted to terminate, and you don't want to talk about that. I mean, I truly want to know where you think you have the authority. I'm not trying to be obstinate. I really am not. I want to know where that came from.
it came from my belief that under Amendment 80, I have the authority to administer the court. And the administrative office of the courts overseeing that is a big part of that responsibility. And just know you asked, so let me answer. So is a big part of that responsibility. And I took an oath to the Constitution and the people of Arkansas that I would do that. I think that I had reason to terminate Marty Sullivan for cause. So
I'm not asking for the reasons to terminate. I'm asking about why you felt like you had unilateral authority when the statute says he serves at the pleasure of the Supreme Court.
I think I get to nominate the director
So
of the
you,
AOC.
so you
I
believe that
think every Chief
statute,
Justice in the past has nominated the director
When-
of the AOC.
when there's a vacancy, that's correct. But as far as termination goes, he serves at the pleasure of the court. I'm asking you, where do you clearly think that this statute is in contradiction to the Constitution? You don't, okay.
So Karen, correct, when Brill became Chief Justice, he did not nominate a new AOC director.
But he could have.
And when Kemp became Chief Justice, he did not nominate an AOC director. He waited, when there was a vacancy, when JD resigned, then that happened, late spring. So, again, I'm curious where all of a sudden you
I
think
think
that,
every Chief Justice has nominated the director of the AOC,
well, again,
subject to the approval of the court, nominated. And
again,
judicial council.
can you tell me when that's happened you did it, I believe, on maybe January 3rd. So in the month of January, the last two Chief Justices have not done that,
What
correct?
difference does it make what month? I don't see what difference that makes.
So we've had two AOC
And those
directors.
directors, yes.
We've had two AOC directors in the last 30 years or so. We've had 5 chiefs in that time, 5 or 6. So I'm not understanding when you say every chief is nominated, we've had several more chiefs than we have had directors. And so unless there's been a retirement or a resignation, no chief is nominated.
I don't think that's true.
So, I mean, when I started in the House in 1999, I think JD was probably the director then. I mean, he's the only one I really remember from my legislative days. That was 27 years ago, 26 years ago. Are you saying that he was terminated and renominated every time we got a new chief? Did Chief Justice Dickey nominate somebody?
No, I don't think so. I think she could have.
Okay, so you said that they all had, not that they all could have.
I'm not sure what you're talking about there. I think they all could have or have nominated the director. I think some of them were happy with what was going on with the director they had. So I think
What does the phrase "at the pleasure of the court" mean to you?
it means that the Supreme Court that they serve at the pleasure of the Supreme Court.
Which you have already stated means you, not the court as a whole. So when someone serves at the pleasure or at the will of, then it would be up to the court to terminate, not an individual member of the court.
I think it would be up to the Chief Justice.
Can I ask how, then,
So at the pleasure of the court really means nothing to you.
Yes, I think that the Chief Justice can nominate.
Okay, but when does somebody nominate? When there's a vacancy? You don't generally nominate for a position that is filled.
I think like a lot of positions that when there is a change in administration, that the court means the Chief Justice can nominate. Yes,
So it appears that you're your thesis on the Chief Justice power all stems from Section 4 of Amendment 80, which says these functions shall be administered by the Chief Justice. Is the Administrative Office of the Courts a court? Or is it a state agency?
I don't know that it's either. It is it operates as the arm of the court in administration.
So if we accepted, which I don't think we do, but if we accepted your broad interpretation of these functions shall be administered, the word these relates back to something. And the something that would relate back to would be the Supreme Court shall exercise general superintending control over the courts of the state, not the state agencies, not these other entities. So even if we give you the broad benefit of the doubt that you're claiming, the actions that you took in terminating these 10 employees was outside that scope because they're not courts.
Do you think they're an independent state agency? Or do you think they work for the court?
I think they're an agency that works for all the courts under our supervision. But I don't think they work
But not the
exclusively for the,
supervision of the Chief Justice. That's your interpretation.
I don't think they work exclusively for the Chief Justice. And if your claim to all this power is under Section 4 of Amendment 80, I don't think that gets you to what you did the first week of January.
Okay.
I just real quickly, I want to make sure I understand your interpretation of the statute on the AOC director. So the statute, and this is, there shall be a director of the administrative office of the courts who shall be nominated by the Chief Justice of the Supreme Court, subject to the approval of the Supreme Court and the Arkansas Judicial Council. If used in that phrase, do you agree that Chief Justice of the Supreme Court and Supreme Court mean different things?
Yes.
So when it then says, subsequent to the appointment, the director shall hold office at the pleasure of the Supreme Court. Does that mean the Chief Justice, or does it mean the Supreme Court in the same sense that literally the sentence in front of it says?
I think it's a function of the court in the statute and that it's administered by the Chief Justice. And I take it.
I mean, if you think the
First of
statute's
all-
unconstitutional, that's fine as an argument. I just want to make sure on the statute that we agree what it says, and then we can have a debate over whether or not it's unconstitutional.
All right. The motion is to,
Sorry, I don't think I've gotten an answer to my question. I want to know how you read the statute. I just for my own benefit so that I understand what your position is, because I'm a little confused and I want to give you every benefit of the doubt here and fully understand your position. So in this statute, you agreed with me the first sentence, it's the same statute, says Supreme Court and Chief Justice of the Supreme Court separately. Those have to mean different things. The sentence that immediately follows says serves or shall hold office at the pleasure of the Supreme Court. Does that mean the entire court or does it mean the Chief Justice?
I think the entire court could vote to terminate an employee. Is that your question?
I'm just asking how you read the statute. Do you think the Supreme Court is used in that second sentence means you, or it means the entire court? Serves at the pleasure of the Supreme Court, the entire body, Justice Hudson, Justice Wood, everyone? Or do you read that the term Supreme Court in that next sentence to mean something totally different?
No, I read it to be the same.
Then tell me how, when it says subsequent to the appointment, the director shall hold office at the pleasure of the Supreme Court, you thought you had the power as Chief Justice to unilaterally exercise that authority under that statute.
To terminate an employee?
To terminate the AOC director, which is the subject of that statute.
I thought I had that authority, yes.
Again, it's a very simple question. I'm just trying to understand. Do you read you told me you read Supreme Court in that second sentence consistent with the language in the first sentence, and it uses Chief Justice and Supreme Court differently. I don't understand where in how you're reading that second provision to give you extra authority. I mean, are you just saying that statute's unconstitutional to the extent that it limits your authority? I'm very confused on the text here, what your reading of the text is. And I'm just like honestly looking for a clear answer so that I understand your position fully and we can engage in that analysis.
Okay. Well, I am not prepared today to engage in that analysis with you.
How about we meet tomorrow publicly, have that discussion? I mean, if you're not prepared today, I'd be ready to come in at 7:30 tomorrow morning to have that discussion.
Okay. Okay, let's do that. That's your motion.
Yep, I move that we pick up this discussion again I'm not wedded to 7:30. People have conflicts. I know people come from other parts of the state. We can make it 10 a.m., same as today. At 10 a.m., we have that discussion over your reading of the statute for the appointment of the AOC director.
Okay. Is there a second?
Second.
All in favor?
Aye.
I'd like to wait on Justice Hudson, if you don't mind.
Can we have some discussion on that before we go?
Can we go and say there's another motion on the table first?
Sorry, I forgot about that.
Yeah, and I'm happy to restate the motion that was on the table, and the motion was, although I believe the majority of the court believes that it was a valid business meeting on January 6th, Justice Baker has taken the position that it was not because she did not call it. So my motion was that these 7 agenda items, every item that was approved by a vote of 5-0, be reaffirmed and reapproved and retroactive back to the date of January 6th. And then who seconded that? Justice Woman seconded that. And so we've had a lot of discussion, so call for a vote.
All right. I don't believe that the court can, I think there are items that in your report of the business meeting that violate the Chief Justice's powers under Amendment 80. And that's what we want to have a discussion about. So I don't believe that this can go forward. So I will not call for a vote on approving the business meeting.
If there's a proper motion in
Yeah.
a second, I think you can vote against it.
I think there's a proper motion in a second. You can vote against it, but I don't think you can decline to take a vote in this situation.
Well, you're probably more familiar with Robert's Rules of Order than I am, having served in the legislature. We've always had kind of a relaxed procedure for that here. And I think I'll follow Justice Kemp's example and refuse to recognize the second and not call for a vote, since that's the position he took when Justice Hudson made the same motion that 4 members of the court could overrule.
When Justice Hudson made that motion, since you brought it up, can you explain to the court what your position was at the time? Were you with Justice Hudson or were you with Justice Kemp?
Also, Justice Kemp. He didn't recognize the second and didn't call for a vote.
I think that, were you going to say something?
No.
I think that the majority of the court is motion, then there's a second. So if the chair is refusing to recognize it, then we can pause for a minute and look at the proper Robert rules, but and decide how to proceed.
I would move.
To appeal the decision of the chair under Robert's Rules of Order.
I'll second that.
I move we call for a vote on that. Appeal.
To move the appeal, the ruling of the chair under Robert Rules of Order.
And so explain to me what that means.
That we take a vote on reversing, overruling the decision.
Decision.
Any discussion on the motion to overrule?
I had to live with Kemp's, I didn't acknowledge my motion.
And said he wouldn't recognize a second.
So I obviously wasn't here for any of that. That seems wrong to me and should never have happened. Like you should have been recognized like any other member of the court. And that's why, I'm going to support the motion to overrule.
I believe pursuant to the rules of parliamentary procedure, you must call for a vote on my motion.
And I call for a vote.
Aye.
That leaves us with calling. We have to call for a vote on the original motion.
The original motion, which is your motion, to reaffirm what you did in the business meeting that you say you had on January 6th before you entered a per curiam reciting facts and doing your own investigation of facts. Strangest thing. All right, call for a vote.
Aye.
I'm just curious,
Is it
Justice
the
Baker.
position of the court going forward that any member of the court can call the court into session and decide administrative matters?
I don't think my position is that any member can call us in, but if you decline to call us in and we have business to attend to, I think a majority can call a meeting.
So your position is that the majority of the court can operate, I guess autonomously. That we can make the court now 5 members instead of 7.
So again, I'm new. That's certainly not my position. As I said at the outset, I view you as the first among equals. And, I'd be happy to defer on certainly everyday matters that somebody needs to be the head. I mean, again, the snow example is sort of an easy example of that. But I do think, consistent with what Justice Womack said, that if a majority of the court believes there's business of the people of Arkansas that needs to be attended to, particularly given everything that had happened, I thought it was important for me as a new member to understand what was going on. And that's why I supported that motion. I wanted to learn what was happening. And I think in that situation, it's appropriate if a majority of the court supports it. As I understood, there was a willingness to accommodate schedules. I understand Justice Hudson had a schedule that could not be accommodated. Sorry about that. But there was a willingness to adjust for your schedule, Chief Justice, and I would have been happy to do that. But I think when there's important business that needs to be attended to, if a majority of the court agrees with that, I think that's the appropriate
What
step.
important business needed to be attended to?
I think I will say the important business that needed to be attended to was the fact that
Well,
you
you
were.
had already the day previously, or on January 2nd, had you not already sent to the state agency I guess, declaration that no employees could be fired?
What we were trying to do is because you had repeatedly declined to meet with us on January 3rd, but then we were asking them to meet with you then that Monday. Because again, we were concerned about the firing without notice and without cause that the court knows of 10 exemplary employees. And so we'd asked in person. I asked you multiple times, the court, 4 of us went in your office and asked to meet.
You asked to meet with me that day, and I said, not today. Right? I said, not today. And then you went down the hall and rounded everybody up and came back to meet anyway. And I said, again, not today. And you started leading them into my office with me saying, not today. I didn't say I wasn't going to meet with you. I said, not today. And nothing was taking place from that point until we met. So what was the emergency?
Again, I think that's probably an inaccurate reflection.
I think the order you entered was inaccurate.
I asked if you would meet with members of the court and you said no. And I thought that maybe if we went back collectively and again implored upon you that would you please meet with us to talk about
And I
the
said,
terminations and that maybe.
You had already notified as it that.
Will you let me finish, please? And not interrupt me. So I thought that maybe if we went in together and said, would you then please meet with us to discuss the terminations because we were concerned about our employees, that we'd give you one more chance and beg basically for you to please meet with us, and you declined again. So then we asked Justice Womack then said, we need to have a business meeting because we did think it was urgent to discuss as a court collectively the issue of these employees and their status. And also at that point, every office, well, most of us, our offices, all of our furniture was in the hallway because we didn't know the status of the moving of the offices and the furniture. And so that was an issue on the agenda as well to discuss what the status was of that. And so there were, several items that were urgent. And so, yes, it's asking to meet with you repeatedly. And then the idea that we could not discuss the termination of essential employees to the court functioning and the status of the movement of the offices till January 23rd, when, as far as I know, we're paid every day as full-time state employees, and that we didn't know reason why we couldn't meet, and the court cannot meet frequently. So, yes. So we went ahead with the meeting. But anyway, it's neither here nor there. We have now approved it. And so it's, I guess, up to you if you want to go to the next item on the agenda.
The next item on the agenda is the proposed liaison selection. Justice Womack.
I think Administrative Order 16 is next.
Oh, I'm sorry. I thought we had discussed that.
Thank you. I was just wanting to be a part of the conversation, and I appreciate you the courtesy of allowing us to do this at the business meeting as it had been held. what the context was to the changes in Administrative Order 16. I'm not saying that they aren't viable, but just wanted to know the context, what brought this up and why the court needed to make this change.
Sure. So, the court, had changed administrative order, some of the administrative orders, a few years ago, and I believe I dissented to that. I have always, felt that it was inconsistent with the Constitution. It also created a administrative burden. And, again, being out, throughout the state of Arkansas, I heard complaints from circuit clerk offices, from administrative assistants, from district judges, circuit judges. And primarily is that Amendment 80 to the Constitution says that circuit judges and district judges can sit in exchange. Granted, it does say, according to the rules set out by the Supreme Court, but I don't think that the rules imagined that, and the Constitution contemplated that it would be that we say, but you can't sit in exchange outside your district. So it was bringing it back in line with the Constitution, and also in line with easing the administrative burden that has been created. I believe since the rule change went into effect, it went from roughly like 400 or 500 special assignment orders that were being signed yearly to almost 1,000. I know that when Chief Kemp was gone, I would sign hundreds of those as acting Chief Justice. And that was sort of a routine issue and a problem. And so going back to the practice that, if it happens a lot of times in the juvenile context, that juvenile judges in different circuits, that they may be gone for a day, that they sit in exchange. A lot of single district court judges sit in exchange for each other. Those hearings have to happen timely, those 8.1 hearings. And so if they're, taking an extended 3-day weekend, there has to be someone to hear those hearings. So there's a lot of that goes on, and it creates an administrative sort of burden. What happens right now is that they have to, and I assume a lot of you know this, but I'll say this for Justice Ronnie, I guess, in fact, is the process of them having to sort of have to reach out to Brookstein, her having to find a special, get that administratively, prepare an order, get that signed, get it back, and then get it filed. It's sort of an administrative nightmare versus them just pick up and do it on exchange. And like I said, it mainly, besides the administrative burden that it takes place, it's getting it back consistent with the Constitution.
And thank you. I remember this court having a lot of discussion and making a change in the past in terms of, we saw a problem with a judicial district reaching out to the Chief Justice for a special without walking down the hall to say, hey, can you, to a circuit judge, can you cover for this? And it was causing, added expense, time, and it seemed, and so we've added that, and now that's part of administrative order. My concern, the only concern I had was that this is not done in such a way to, I guess, overlook conflicts. So that I wanted to make sure, and Kristen, you might be able to speak to this. This says that it's in the event of temporary inability to serve. And I just wanted to make sure that we're not allowing a circuit judge who has a conflict, or a district judge who has a conflict, to be able to cherry pick the next person who is going to be able to hear that. So I was wondering if maybe we could have a little bit of clarifying language, maybe something like due to unforeseen circumstances, or just something to give it a little more of a guardrail in terms of and that's why I want to know, like, the use, what's the context of this and how is it going to be used?
And I can answer that. I mean, if they're conflicted out and they have to recuse, then I think that we had that issue in the past. And so there's that separate process. So if if they're recused, then they don't have the ability to set an exchange because they're off the case.
I wanted to, see here. I just wanted to make sure that that the language in this rule, and Kristen, and maybe you can weigh in on that, that the language in this rule makes that true. That it doesn't get willy-nilly with, one judge getting to cherry pick another judge to take over for a situation that's actually a conflict. That was my concern. So,
Part is still there about, our main concern also was attorneys stepping in.
yes.
And that's still
yes.
there. I mean, we haven't touched that.
Yes. So does anyone feel like there would be a need to clarify that language a little bit so that, or does the language in the event of temporary inability, is that code for I've got a sick child and I need to step off the bench, or help me understand that, please.
Kristen, you wanna weigh in?
I can weigh in. The way that that's been interpreted up to this point is that temporary inability would just be the day assignment, sick child, or they have a field trip, or maybe you have a last minute doctor's appointment to attend to, which is viewed differently as a situation of conflict. And I know that that was something that was very important to the court to address, and there's actually a recusal. That's different.
Right. Well, thank you for those explanations, and I'm well with it.
All right. I don't suppose that just, it's been circulated twice, and I think you release your hold, and I really smiled. So that can go down. And now, item 10, proposed rule liaison selection.
Okay. Oh, there's one for Rhonda also.
You know, the Court of Appeals, they have the
It's still over there.
is there?
I don't think that they have much use for it anymore, but they still have it.
Okay, so I had circulated a while back a proposed rule on liaison selections. And we've kind of talked a little bit today about custom and practice, and we've just kind of had this thing where whoever is most senior just kind of gets whatever they want, and number 7 gets whatever's left. And so I felt like it was appropriate for us to memorialize and create a process. This is the rule that was adopted at the previous business meeting, and one minor change to what was originally circulated. And then after we adopted it, I incorporated that language and sent it out to everyone again, was that initially it said that we would have 2 liaison positions from the court for every entity that had full-time employees dedicated to them. Really, the purpose of that was to kind of get to those agencies that have a bigger budget, just so we have more eyes on what's going on with the employees and the budgets in those entities. So we did narrow that down in paragraph number 2 to where there'd be 2 liaisons to professional conduct, professional programs, access to justice, and JLAB. So there are 2 provisions that I think we address before we get started. First is with respect to the term that each selection would be. It's defined as, you know, the way the rule reads, we meet in January of every odd numbered year to select the liaison assignments. Each selection would last for a period of 2 years unless there is a position that has a specific term length or time frame that is designated by rule or law. The one that I am aware of, because I'm on it, is DCRAB, the District Court Resource Assessment Board. We pulled the per curiam on that. The appointment for me runs through April 30th of this year. So that wouldn't be part of the selection today, but in April, there'll be a vacancy and then, we could select again for that particular position. Does anybody else know of something that they serve on that has a time frame specific? It's a term that expires at some particular time?
Say only the Commission on Children and Access to Justice are both by procurator
Okay,
as well, but they don't have a time frame, but they're both like.
okay,
And we actually serve on it, they're not liaisons.
okay.
So it's,
So Access to Justice is not a liaison?
it's not on the commission, and the same thing with the Children's and Family, you're not a liaison, you're on it, you're chair. It's not chair.
So do we need liaisons then, in addition, someone different?
So that was the question is with those three, do you even need liaisons because you're actually members? You're actually on
So Access to Justice, the Children and Youth Commission, what was the third one?
in yours, one you're on.
Yeah, mine's for a specific term though. I mean, I'm,
Well, you're on.
yeah.
So those three, there's actually,
So you would say take those three off the list here? So the rule says we would have two to Access to Justice because of the employees in the budget. So would we put another member on the commission or would we have Barbara on the commission because you're appointed for some term and then another person as a liaison? I don't have strong feelings on how we do that. I think it helps for us to adopt how we're going to do it though. Anybody has any?
I guess you can.
I guess you could split it and have me on the commission and then just have another liaison to the commission, and that way I mean, I don't know if it has to be done per curiam, as long as we meet the requirement of one appointment. I mean, I don't know, however y'all prefer. I think the benefit of having a second liaison is if there is, in such a large group, and the concern of the money, the amount of money, and then also just if I think it's a good opportunity for a second justice if it's to serve, to get to know that group and if for some reason I step off because my term ends or whatever, then somebody's prepared to step in without a lot of learning curve. So that's the reason.
So would we just, instead of calling them a liaison, appoint a second person
That's
to the
fine.
commission? Or is the commission statutorily defined or by rule or?
you were thinking more, have you on the board and someone else as a liaison, like oversight, kind of
Right.
backing around.
I mean, however y'all prefer doing it, we could put another person on the commission, but
I guess when we get to Access to Justice, we can
okay.
talk about that. The other provision is for holdovers. Sorry, Justice Bronny, but the part of the rule that talks about that is that any returning member who currently, as of December 31st, serves on a committee in lieu of a first round selection can designate that as their committee that they want to serve on. If you want to start fresh, when we go through the selection process, but once we identify the holdovers, then the process would be we start with Justice Baker and go one at a time around the table to Justice Bronny. Everybody picks one and then we go through again. So then we keep doing that until all the positions are filled. So, any questions about the process? So I guess we would, and I've got the list as of December of who was on which commissions here. So I guess the process would be Justice Baker, you would pick yours first and then, or actually, before we go through that, do you have a holdover that you want to designate in lieu of your first round? So I don't know if I've missed any, but what I have you on right now is Continuing Legal Ed Board, JLAP, Board of Law Examiners, and Professional Practicum.
The professional practicum was disbanded
So,
by per curiam some time ago.
okay.
So I don't know why it's still on the list.
But basically, I guess we would,
Oh, yeah, we haven't,
okay.
they don't even do that anymore.
Yeah, that's
Done.
gone
Okay.
and been gone.
Take practicum off that list. Okay, so of your others, do you have a holdover or do you want to wait and select in the first round?
Well, I think that it's gonna depend on, I, holdover, I'm not sure I understand.
So,
Same.
so the
Pick
holdover
one.
part of the, and the rule is attached there if you need to see it. Number 4, paragraph 4 is the holdover provision. Says each returning member who serves as a liaison to a committee or entity as of December 31st of the preceding even numbered year may choose to designate one of those committees or liaison positions as a holdover committee. And you would do that in lieu of making a first round selection. So as number 1, it doesn't really matter. But, you know, if Justice Webb had one that she didn't want me to steal, we'll go around, everybody says, this is my one holdover, and then you don't pick in the first round otherwise. So.
Effectively giving me the first one.
Well, no, because we all 6 get to hold over and then we go 1 through 7. So you really get the 13th pick. So
It's really fair.
It's better than it would have been.
Well, if we're going to do the Office of Attorney Regulation Council instead of professional conduct and professional programs.
I would say until we actually adopt that, then we probably ought to go with what exists now, and then we can, at the first business meeting after that gets adopted, if it does, then we could address those changes at that point.
I guess if I'm picking first, I'm going to say Office of Professional Conduct.
Okay, so you're not choosing one of your current as a holdover. So we'll come back then to that so Justice Hudson, do you have a holdover that you want to keep?
No.
Okay, Justice Wood?
Well, if I'm keeping children and families, because I'm on that as chair,
As an appointing committee.
then I will keep.
Okay, so we're. They're not alphabetical, so take me a second. Let's see. Okay, I will do court security as my holdover. Justice Webb,
So.
if you're on access to justice as a member. So model jury instructions, criminal is what I have as your other one. I don't know if you're on anything else, but that was. So do you want to hold over there or do you want to wait and select something else in the first round?
I'll just stay on model jury instruction criminal. And I'll stay on access.
Okay, Justice
I'm
Island.
really picking one holdover, so
Yeah, I'm confused.
I am too. Model jury instructions.
As members, not liaisons.
Yeah, that,
Actually appointed members.
Oh, that's the access one. Yeah, so it's not a holdover.
It's
just-
not a holdover.
That's-
It's just there, but if y'all want me to only do that one, I'm fine with but leaving the other one up for grabs too, so if you. I'll defer.
Was that model jury instructions civil?
Criminal.
Criminal.
okay, Justice Highland, do you have a holdover?
Yeah, I'll take OPC.
Okay, so now to the open process first round, Justice Baker.
All right. I picked OPC last time, is that right? And I shouldn't have.
Well, we just did holdovers first. So now if you wanted to pick it, you could do that now because it's open.
Yes, Board of Law Examiners. Yeah. Yeah, OPC.
OPC. Okay, Justice Hudson.
So, Board of Law Examiners is an option.
Mhm.
Yeah,
Yes.
I'll do that.
Okay, I'm gonna have to distinguish CH and CH here. Is it? Okay, Justice Wood.
There's something that Justice Ronnie that you wanted. I don't know what's left.
If somebody thinks the model jury instruction is civil.
But-
So that's probably the one I would take.
Right.
If it gets to me, but
I'm gonna take civil rules, but if one of the newer justices decides they want us to. It's wrong. Civil rules,
Civil practice.
yeah.
Um. I'll do, you said you wanted civil model instructions, right?
yeah, that would be my preference. So, but
I'll do JDDC. So Justice Webb,
Let's start with DC up to.
No,
it doesn't. If you want that, I can take something else.
I kind of would like it.
Okay,
Because you're gonna get rid of it anyway.
I'll back up and I'll take something else. So let me pause here. In the rule, it says that Office of Professional Programs would have two. We actually have professional programs divvied up into Board of Law Examiners. And what else is under that?
CLE.
CLE. So how do we want to address that since we don't have professional programs as one thing? Do we want to do two?
Right now, like you got it for a lot in your sense.
So one each to those? So we can amend that rule later. So everybody okay with that? You threw me off when you took JDDC.
I'm sorry. Can we pick something else?
No, you're fine.
wait,
Yeah,
is office professional conduct different than office of professional programs?
professional programs is what we were referring to, like Nancy Gibbons shop over there with
Bar examiners and
CLE, yeah. So,
Nobody's taken.
So the board's different than,
Nobody's taken OPC.
yeah, Highland and Baker.
Oh, so nobody took OPP.
Right.
I think Board of Law.
She took Board of Law Examiners. No one's taken CLE yet. So
Or OPP.
So there's no-
we don't have that as a standalone
it's
on
not
the
a
list.
committee. Just-
That's wrong.
Yeah, it's wrong.
We
Oh.
broke it into two parts.
Okay, it is up there. Okay.
Yeah, it is. That's what I was trying to figure out,
Okay.
where I was writing.
But you've also got it.
So I guess we would have two to OPP, just dealing with Nancy generally, and then one each to Law Examiners and CLE because they're separate. Okay. I tell you what, if you really want JDDC, I'll take OPP. If you don't, I'll take JDDC. So,
You can have it. I'll just do something else.
Are you sure?
Yeah.
Okay, I'll take JDDC. Okay, Justice Webb.
Put me on. those people for them.
Okay. Justice Highland.
Take the, model jury instructions in the criminal committee.
That's mine.
Barbara has that.
There. How did you get?
I held over on that.
Criminal practice is available.
I'll take, okay, criminal practice, I'll take.
I mean, I'll let you have it if you want.
No.
Choosing number 13 in the draft. Justice Bronny.
Model jury instruction civil.
Okay.
Others for not having taken that.
All right, Justice Baker.
The district court resource assessment.
So that's the one we said comes open in April. So I'm on there for a term that expires April 30th. So we would have to,
Wait till April.
yeah, so May 1st, you could pick that if you wanted.
I don't know, is
Good.
it doing anything now?
Mhm.
We're
Yeah,
still doing resource assessment. We're adding
Doing-
district judges.
Doing that, we also have, just dealt with the last of the part-timers coming into the full-time system. We've been working with, Carol Dalby to put together a bill for, some of the operations of the district courts in terms of the statute has information on, where they have to meet and if they were formerly a city court, if they continue to meet, what they have to do and what they have to have in the
Is
courtroom.
this operating? It's operating primarily the same way JRAC does and judicial council assessing.
Similar to that, but it also has kind of taken on this role of working with the legislature to kind of come up with a transition for some of those smaller courts.
Okay,
So do you want to go ahead and pick that now and designate that as of May?
yes.
Okay.
Which go with district court, make sure I've got it right.
Resource assessment.
And if you would just
You
make a
count
note,
Court security, is that right?
I did.
Okay.
You might just make a note to do a per curiam, appointing you, since that's actually an appointed liaison position for May 1st. So when we,
Okay.
okay, Justice Hudson.
Are there two for JLab?
Yes, and no one's taken either so far.
Yeah, what are the other two? But what else has two?
So OPC, and then that already has two, OPP, which is going to kind of get congested with the things under it. And then Access to Justice has an open spot. So JLAP, OPC, OPP, and Access.
I guess OPP.
OPP. Okay, Justice Wood.
I feel like I have an extra one in everybody, so would everybody like me to defer
I'm gonna take a bye.
and.
No, you can do more work.
No, so I feel like out of fairness, that I should pass.
I appreciate that.
Yeah.
So we're back to me. Since no one has jumped up yet for JLAP. I guess I'll take one of those spots. Justice Webb.
So some of these, are they, I mean, like the child support committee, is that actually functioning?
We did a ton of work. We totally rewrote the process for how child support is determined, and now it just meets kind of as needed if there's an issue that needs to be tinkered with to fix something. So it doesn't do much anymore.
Or it could be like me, that you have 30 seats.
I'm thinking like, I'm gonna put the same what she said.
Justice Island?
Is anybody on COE or code revision yet?
No.
Code revision doesn't really do anything.
We just appoint 3.
Yeah, that's all we do.
All right, then I'll just COE.
But you get your name in front of the red books. So.
Oh, well, there's that.
Or at least we did when I was on code revision, when I was in the legislature. Oh, you're just a liaison, okay, yeah,
That was my first liaison to when I was with Governor Huxley.
okay. So are you taking, what are you taking?
I'll take COE.
COE? Justice Bronny.
I was excited about code revision, but now you've informed me that it doesn't do as much as I assumed it would.
I mean, they meet after the session and kind of clean up stuff, but
You're not.
they used to anyway. So.
Nice, really find this all. Court reporters, you can digitize those two. I'm not. Court reporters are a lot.
Well, that's not the word, I just, I don't know how much like expertise I'm gonna have to, like, lend to that. But unauthorized practice of law. Alright.
It's open. You want that one?
You know, there was actually a case out of Fort Smith on that criminal case. No, for practice.
Yeah, we'll do a CLE on that. That was pretty interesting.
You only have 2 now.
Yep.
Okay, so just as a rundown, before we start the next round, if you're not following along, we have alternative dispute resolution. We have one more seat on JLAP. We have client security, code revision, child support, a second person on access to justice, and court reporters. So, Justice Baker.
We'll take the other position on JLAP.
Justice Hudson.
Read the menu again, please.
ADR. JLAP is done now. So client security, code revision, child support, and court reporters.
No access to justice.
Oh, I'm sorry. Yes, there's a second spot on access to justice.
I won't do that.
You guys are on TV.
Who else is on access? Is it
Barbara. Okay, Justice Wood.
Yeah, professional programs.
Back to you. You want court reporters? You can have it back.
Pass them to one of the ones that justices that have.
Okay, so what does the justice who's the liaison to code revision actually do?
Nothing.
You
There's
don't-
not even a report back. There's not even a report back.
Okay,
Maybe you could do something, like you should go to their meeting.
But anybody, yeah.
I guess I'll stick with child support then. Okay. Justice Webb.
Which one did you pick?
I took child support again, unless you want it.
I'll let you go.
So you have ADR, you have client security, you have code revision, and you have court reporters.
What is alternate dispute resolution?
They, what, licensed mediators, I guess.
I can take that.
Okay, that's just Highland.
Okay, we got three. Is court security open? Or is that
No,
yours?
that was my holdover.
Okay. Well, I hate to be that guy. Can you read me the menu again?
You've got client security, code revision, and court reporters.
I'll do code revision.
Right, Justice Barani,
Wait, read me the menu.
client security and court reporters.
Nobody else had any.
There's only one ADR spot and Justice Webb took it.
Client security fund is deciding how much money to pay out people that have been, had their money stolen from them by attorneys.
Okay.
It's millions of dollars in.
It's important, but they don't meet frequently, do they?
Well, we.
Hit and miss.
We've had. Reluctant membership to award any money. The problem. Saving it? You can. Pay membership.
I'll take that one, so we should talk after.
All right, Justice Baker, would you like court reporters?
No. That's
Justice
the only
Hutt?
thing left.
That's the only thing left.
Oh, I'll do court reporters.
Okay. All right. I will try to put together a list with all the
I wrote it down.
names attached and send it around.
We'll find out how these people meet, and somebody Marty or somebody can get us information on these.
Yeah, especially for the new people who really don't matter.
And I guess the question is, Justice Baker, are you going to accept us doing it this manner?
Being liaison,
Yeah,
certainly.
okay.
I want to make are we to the end of, I need to make a motion to set the next business meeting. And we can,
Do what?
I want to make a motion that the next business meeting, when the next business meeting would be held. To be held, either by majority, setting by the majority of the court, or we can pick a date and time right now.
We're gonna have to act on this, getting the budget hearing set pretty quick. If we're gonna have them in April.
We've got those set. But
Yeah,
to the next business meeting,
Well, that's right. Courtney gave me the, sorry.
the next business meeting.
319. We could probably get those done in 2 meetings instead of putting it together. We will do the business meeting. on that same
February?
day, on the 13th. Or
13th. It's March 19th.
19th, I mean.
I mean,
Often do we normally?
We haven't had one since last May.
But I figure with all this stuff coming up, we probably all need to have a date for one and get it set.
yes.
People get it on the calendar. I mean, if we wind up with no business, we could always, I guess, suspend it or. I just trying to get my calendar. So I guess March 19th,
Or February 19th at 1.
February 19th.
That's the Wednesday before the 20th conference. At 1.
I'm not a problem with that.
Earlier, the better on my end.
1 o'clock, we can grab one.
They have to drive there, that's why.
Yeah, I'm responsible for 2 children that evening, so it's not even.
Oh, that-
Oh, it won't be a.
Only that day.
Is it that particular 19th day?
Yeah,
Okay, well, we can
but if we start at 1, it should be fine.
do some. Okay,
We may not have anything we need to do, but we'll put it on the calendar.
Right.
Yes,
Like, people-
the 19th. We're gonna be here doing budget. And if there's any business,
no,
Well, it's just
February.
February.
Oh,
19th,
February.
the Budget would be March 19th.
Yeah.
I guess in February 19th meeting, one of the things we can discuss if we do that meeting would be who to put in which order on budget, and who can be ready for the presentation, like which of the. Order.
was there anything further? I've discussed everything on the agenda.
Just to clarify, are we meeting tomorrow, or do people, having had time to think about it, not want to meet tomorrow?
I vote no.
I had to discuss the AOC statute, but if people don't want to meet tomorrow, that's fine with me. I couldn't remember whether we voted on it or not.
we didn't vote on it, but
Like your motion got withdrawn because her motion was on the table.
Right.
Yeah, right.
Voted on.
I don't know that you're gonna get a resolution.
No, I don't need to hold a meeting. I will extend to the Chief Justice. I am happy to discuss those issues at any point. I'm open to your interpretation of Amendment 80. I just wanted to make sure I understood the statutory question. So at any point, if you want to chat about that, I'm happy to do that.
Okay.
All right. We'll be adjourned.
Totally separate from us, unrelated to us.
Okay.
It's county. um,
As a point of note, nobody signed hardly the correct spot.
I was told I wasn't signing the first one, so I didn't
Okay.
sign the first one.
Oh, I don't know if they were flat, I signed the wrong.
One of them was from last.
Okay, then, yeah.
Can't be signed.
Okay. I signed them wrong.
stuff on the one.
I don't know.
Slide your names on it. I don't
Yeah.
care.
It's, then I definitely, I was putting 3, so I think you signed 4 in some places.
Right, because there was one this year.
Yes.
From last year.
So I don't know, I think I'm sure I know for certain.
No.